I am for the petitioner. Transfer matter. So I want to withdraw the petition. My instruction is to withdraw the petition.
To withdraw it.
Yes, Lordship. They have already amicably settled, Lordship.
Item number 24. Items paper cited. Also petition. Other side is also present.
I have already informed them. Morning.
It is submitted with the information to the other side, and as per the instruction of the client, she wants to withdraw. Considering the, as the matter has amicably settled, also considering the submission made by Ms. Prasetti, case is accordingly withdrawn.
All right.
May I please, my lord, with the consent of other side, my lord, I beg to mention item number 25, my
This
My
is
lord.
also transfer matter.
transfer matter.
So I'm respondent number 1.
Let it be come after 3 weeks, ma'am.
After
After 3 weeks, ma'am.
3 weeks. Otherwise, case is in the order column. Why it is in order column? We have already appeared.
My lord, appear.
So respondents, I mean this
Service already completed, ma'am.
service is already complete.
My lord, they have not filed affidavit, ma'am. It should be come in admission column.
But Mr. Iman, but you are Mr.
Wasim W.
W.
Actually for Mr. A.
Acha. You are W.
Hawk.
W. Hawk appearing on each for the service is already completed. Let the matter be accordingly listed in admission column after 3 weeks.
My lord, interim may be continued, ma'am.
Was there any interim?
Ma'am.
Interim be continued.
Obliged, ma'am. High level.
My please, I beg to mention item number 32 billing. In this case, the service is voided to the sole respondent. So the matter may be listed after 3 weeks.
Mr. D. Calvin, learned consultation, and it is submitted that requires for the office of the service is still awaited for the source. Service be awaited till next list accordingly. After 2 weeks, will do
Yes, please.
as on it.
Obliged.
May it please the lordship. Lordship, I beg to mention item number 10, 11, 12 from today's daily list. In this matter, my lord, we have taken the consent from the other side, my lord. We want an adjournment in this matter, my lord, as my senior is out of station.
Fix the date.
Who is your senior?
Mr. N.N. Upadhyay.
With the consent of the respondent side, the learned counsel, you are Mr.
S. Upadhyay, ma'am.
S. Upadhyay appearing on behalf of Mr. N. Upadhyay, paid for an adjournment stating that due to personal inconvenience, the learned and his counsel is considering the prayer, considering the submission made by the counsel for the petition, let all the matter be listed after
Any date, my lord.
last week of March.
Deeply
24th of
obliged.
March.
May I please, your lordship? I beg to mention for item number 21, lordship. Daily list, lordship.
21.
Seeking for the adjournment, lordship, with the consent of the other party.
Appearing for? You are appearing for?
Yes,
Appearing on behalf of whom?
Be cautious.
Be cautious. So, but the other side, in
I have here the
acha,
respondent.
acha, in I1 IA you are there.
Yes, lordship, I am for the
In one IA you are for the respondent.
Yes, lordship.
That means the respondent had filed the IA.
Yes.
Okay. And 3 names are there on Mr. One more IA is there. So Mr. N. Upadhyay name is there and N. Chaudhary is also there. They are appearing for the respondent already.
Your Lordship, I'm appearing for the Miss on behalf of Miss N. Upadhyay and on the behalf of applicant. Bodia.
No, N. Upadhyay, that means you are appearing in the main case, you are appearing for the respondent.
Yes, Your Lordship, I'm appearing for the applicant for the IA, ODI.
No, for the IA, you are appearing for the main case. The CRP, you are appearing for respondents.
Respondent. I'm the petitioner. Lordship. Yes.
So service is already completed. Is there any other respondents to be appeared?
No, no,
You have appeared. How many respondents are there as a whole?
Lordship, there are 7 respondents. There is a IA. There is some
I is okay. How many respondents are there now?
7.
7. You are appearing for all.
No, I'm appearing for two applicants in the IA.
Uh,
There's Samir
Kumar
Kumar Roy and Sabir Kumar Roy.
I would you know.
Seven.
Let the matter be reached, then only we can pass the order. Not now.
Second,
Let the matter be reached. You have to
Don't-
peruse the case record. You have to peruse the case record. Wait for your turn.
My lord, item number 18, I want to peruse the record.
Item number,
18, I want to peruse the LCR, my lord.
it's a bail hearing.
I want to peruse this.
You have already received the case record.
Yes.
May I please, your lordship? I beg to mention item number 9, your lordship, for adjournment with consent of the other side.
So I am
9.
respondent of you.
You are for the,
I am for the petitioner.
I'm
you are for the
respondent.
petition. You are for the respondent.
Lordship.
With the consent of the other side, done it. Wait for an adjournment. To which the learned counsel, Mr. Mboro, raised no objection. For the respondent, prayer allowed. The matter will be how many weeks you need here?
Your lordship, kindly fix it 12th February.
12th of February.
Yes.
12th of February is not. If you
Okay.
take an adjournment, then it will go in the most probably in the
Can
month
you
of March only.
Kindly 19 of February.
Okay, then 19th of February.
Lordship, interim remains in,
Interim was there.
yes,
Interim be continued till next day.
keep the lordship.
Lordship, may I mention item number 40, your lordship,
40.
40, your lordship. Lordship, it is for the consideration of IA for condonation of delay. We have filed an affidavit in the matter, your lordship. And
No, you are for the appellant.
I'm for the appellant. your lordship.
appellant.
Yes, your
So you have already filed your condonation, I think.
condonation is also filed and an affidavit has also been filed.
Ah.
Lordship, the difficulty is that I'm traveling actually. I'm actually counsel from Delhi. So if your lordship keeps it at a fixed time at 12 o'clock or 2 o'clock, then
Today you are returning.
yes, your lordship.
Okay, at 2 we are fixing it.
2 o'clock, your
Yeah.
lordship. Obliged.
May I please, your lordship?
Yes.
Lordship, this revision petition has been filed against the order dated, my lord, 10/9/2025, TSD 27 of 2022, my lord, passed by District Judge Honorable Dorong, my lord, by which the application filed under Order 11 Rule 1 was rejected, my lord. Lordship, may kindly come to page number 52. This is the application which was filed, my lord, seeking, my lord, interrogatories, my lord.
52.
52, my lord, is the application, and page number 53, these are the questions, my lord. To as per this application, the petitioner, my lord, was filed, my lord, for interrogation. In the main case, my lord, the facts of the case is there. The wife, my lord, the husband was filed that divorce petition, my lord. He was a personnel, my lord, defense personnel, my lord. Yes, working under CRP, my lord. Thereafter, my lord, what happened? He was posted outside the state, my lord, and she used to now present petitioner. She used to reside in her matrimonial house also, my lord. Now, after filing of the divorce petition, my lord, they came to know, my lord, he has some relation with some other lady, my lord, and some child was also there. That is why, my lord, after filing of this WS, my lord, she filed this application, my lord, seeking these questions from the opposite party, my lord. And the impugn order, lordship, will find from page number 55. And relevant portion, my lord, 56, where may I read 56, my lord, where the law is quoted, my lord. Honorable Trial Court, my lord, quoted that upon a plain reading of mandate of Order 11, Rule 1 of the CPC, it appears that the provisions reads as follows. Discovery by interrogatories. In any suit, the plaintiff or defendant, by leave of the court, may deliver interrogatories in writing for the examination of the opposite parties or anyone or more of such parties, and such interrogatories, when delivered, shall have a note at the foot thereof stating which of such interrogatories each of such persons is required to answer, provided that no party shall deliver more than one set of interrogatories to the same party without an order for that purpose. And this is the only interrogatories we have seek for, my lord. Provided also that interrogatories which do not relate to any matter in question in the suit shall be deemed irrelevant, notwithstanding that they might be admissible on the oral cross-examination of a witness. These interrogatories, my lord, have direct connection with the case, my lord, because the case was a divorce suit, my lord, and the questions she had put in, my lord, was relation to her life, my lord, married life, my lord. And lordship may kindly see the next, where is the next page 57, where the honorable
But,
trial
these
court,
questions, most probably one lady name is also there.
yes,
So now the question is, at the time of filing your WS, whether you have made any statement in that regard,
my lord.
that he is having an illicit relation or a adultery. with
Yes,
some-
yes. In our WS, my lord, we have put some, my lord. But in later on, she came to know, my lord, about this, my lord. That is why,
So they obviously at present, I mean, from your WS, it seems that it may not be connected with your case only. Then why don't you file the petition for seeking leave to file your additional one?
because already one additional WS she had already filed, my lord.
Then why how many times you are going to give such kind of chances? If one WS have already filed, additional is already filed.
My lord,
Now we have come with such a
with
petition that
due
those
respect,
are
my
not
lord,
the questions.
with due respect, my lord, this is a family matter, my lord. She was not aware earlier, my lord, about the laws. So this is a family, my lord, matter, my lord. So some court may, some lenient view may be taken, my lord, for that, my lord. Because this petition was rejected only too technically, my lord.
Yes, technically it is, but because
Only this
your
was rejected, my
WS
lord.
doesn't say so. Anything, there is nothing at that
My
statement.
lord, with due respect, my lord, only rejection or my lord, the reason was that, my lord, lordship may kindly see the next two paragraphs of 57, my lord, where first honorable trial court had admitted that it is the settled position that though interrogatories can be sought at any time, my lord, but the same has to be bona fide and without any undue delay obtaining leave of the court. This court, honorable trial court, my lord, had rejected only saying that it was delayed. Because court himself, itself saying, my lord, it can be filed at any stage, my lord. Now, Lord, may I read next paragraph, my lord? In this case, respondent was unable to incorporate any explanation in the petition in question why interrogatories could not be furnished at the initial stage. This is the only reason, my lord. Itself, and what was the necessary to seek reply by interrogatories by an unusual belated stage. This is not unwanted, my lord, unusual belated stage, because almost frame has been charged, frame, my lord, charge has been framed. Thereafter, evidence not taken yet, my lord. So this is not a stage which, my lord, before judgment we are seeking, my lord. So at this stage, my lord, lordship may kindly issue notice, my lord, because these are family matters, my lord. We can maybe amicably settle, my lord, after notice, my lord.
So coming to know about his suppose this illicit relationship with another lady, are you still not?
That is why, my lord, we will. I'll also. I'm trying, my lord, to convince my client. That is why it is at least notice may be issued, my lord.
You are here legal counsel.
Yes, yes.
As judgment, the legal for the applicant. This petition is in the Article 227 in India, setting aside the order dated 10/9/2025 passed by London District Judge T in TS Learned district judge here, Dorong, na?
Dorong, yes,
Dorong
Dorong Mongol.
in TS, bracket of D up to, from 27 up to 20. Stop issue notice to the sole respondent for speed post and HGF post. List matter 3 weeks will do. List matter accordingly after 3 weeks. Isn't it? Just take step immediately.
Lordship may observe that interim will be considered on the next date, my lord. After serving
What kind of interim do you need?
to
What
stay,
is the stage of the
because,
case now?
because my lord,
No,
now
stage-
before evidence stage, my lord. Otherwise, my lord, this case will be infructuous, my lord. That is, lordship may,
No, it is evidence before charge or what?
already the issue has been framed.
It is a case of not charge. No, it is TSD. I think.
Yes, my lord.
Or that?
Then, as
You're
part of
framing
order,
charge.
my lord,
Issues have been.
issues already framed.
Let us see. We'll see.
That may be observed, my lord, that on the
Okay,
next
so-
day it will be
After
considered.
3
Highly obliged.
Met Your Lordship. My lord, is the instant case, my lord, against judgment and order passed by the learned additional district judge Kasar, my lord. And petitioner preferred in succession case, my lord, and along with my one daughter and one son, my lord. And learned trial court, my lord, without considering my specs, my lord, my conscience has not been considered. Lord. Would you kindly have a look at the plaint at page 9? Page 9, Lordship. Yes. With the petition 370 to preferred, my lord, for collection of a debt and securities of my deceased husband, Manish Kumar Sanchez Sancho, who died on 6/6/2020, my lord. Lordship will find, my lord.
You are related with your the deceased?
I'm wife, my lord.
You are the wife.
Yes. Well, I'll come, my lord. Then, my lord, I am the one. Number 2 is my daughter. Number 3 is my son. Next, my lord, respondents. The first respondent is Balkeshi Devi, is my mother-in-law. Mother-in-law. And number 2 is the first wife's daughter, my lord. This is the question involved. First wife's daughter, my lord. Then, lordship, only 2 paragraphs from my plaints, page 11, paragraph 2 and 3. That above petitioner number 1 is legally married wife of the deceased Manish Kumar. Their marriage was solemnized according to the Special Marriage Act on 21/7/14 before the marriage officer Silchar during conjugal life. The petitioner number 2 and 3 were born out of their wedlock, that is on 3/6/17 and 14/12/2018. Para number 3, my lord. That the husband of the petitioner number 1 before her marriage, he had, this is the question involved, he had married one Lakshmi Devi of Bihar. And out of their wedlock, one female child was born, namely Shalini Kumar. She is the respondent number 2 here, my lord. But after the birth of the said opposite party number 2, her mother Lakshmi Devi fled away and with another person and remarried and left her daughter, that is opposite party number 2, at her father's house. Thereafter, the husband of the petitioner number 1 married with her according to a Special Marriage Act. And number 3, 4, my lord, the petitioner begs to state that
Was a service holder or what?
my husband was service holder. Yes, my lord, paragraph 4 I have stated
So
this.
you are not the nominee. Then.
My lord.
You are not the nominee.
But it is the, my lord, my nominee question, it is not disputed on the epidicial, my lord. Paragraph 4, my lord, I have stated. The husband of the petitioner number 1, the father of the number 2 and 2, serving as a epidicial as Sahayak, Halak and Stabli. Now, my lord, page 13, para 15. Para 15, I have, my lord, document I have annexed, first annexed 1, this is the most vital document I have enclosed here, my lord, is the marriage certificate, that is Special Marriage Act of petitioner, deceased husband, the petitioner, birth certificate, and death certificate. What is my prayer in the succession case, my lord? And next page 14. The scheduled debt and securities, my lord, that is 8,50,000, my lord. And for this purpose, I preferred in succession case. In this case, my lord, admittedly, the first wife eloped with some other person, she remarried. Same has not been denied by the respondent number 2, that is my mother-in-law. Lordship, kindly have a look at the cross of the dependent DW1 as page
That's okay.
35.
Now question is that what is the order passed by the learned trial?
Yes, my lord. My lord,
Page number which?
before that, my lord, this evidence is very important. Then I could,
Okay, when
yes,
you
yes,
look at
yes,
case,
yes,
now,
yes.
What is the result?
Yes, yes.
Your
Lordship, kindly
case
have a look.
result?
Judgment at page 37, but operative portion, only I'll take your lordship, operative portion, page 46. Issue number 3 and issue number 4 and 5. Page 46. Issue number 3, my lord, paragraph 15. Whether the petition is bad for non-gender and misgender. The first party, my lord, there is no material on record to substantiate the fact that any important person is left out in this case. All the necessary parties, including the mother of the deceased, has been made parties, and this issue is decided in favor of the petitioner. Now, my question is, my lord, the learned trial court, my lord, has in the subsequent paragraph, I will take your lordship that I am failed to produce the divorce certificate of the earlier wife. So the court has not accepted my marriage with my husband, my lord. So competent necessary party in this matter, the first wife, but learned trial court has not raised this point in this case and said that yes, this rightly all the parties have been made party in this matter. Now, my lord, page 49 and 52, only one paragraph I'll read. Page 49. And paragraph 16, Roman 4. On meticulous scrutiny of the entire materials on record, it appears to me that the first wife, namely Lakshmi Devi, has not made any claim in this case. Since he is not a party, my lord, the question doesn't question does not come that he's made claim, but since he didn't hadn't seen necessary party, court would have directed to make up implicit to party, but same has not been done by the learned trial court. Rather, the evidence of the PW1 proves that the fact that she has eloped with another person, but she has a daughter named Srimati Shalini Kumari, that is to conclude DW1, Srimati Balkeshi Devi is the mother of the deceased. It also crystal clear that the petitioner, namely Srimati Neelam Gola, is the second wife who married to the deceased during the lifetime of first wife, namely Lakshmi Devi, without getting any decree of divorce. In fact, the petitioner said could not produce a decree of divorce in this case to substantiate that her second marriage is valid. That being the position, I have not to consider the following settled legal provision in this case. Now, my lord, final conclusion at page 52, paragraph 6, Roman 14. Now, this is a case claiming for succession certificate to collect the debt and securities of amount of rupees so and so plus interest from the debtor, namely Assistant Manager APDC Halangari. In view of the aforesaid discussion, the petitioner's marriage cannot be legally held to be valid, but her second two minor daughters, children, are entitled to get their share of their father's property. Secondly, the daughter of the first wife, namely Shalini Kumari, is entitled to get one share provided she has to brought to the court at the time of issuance of the succession certificate for verification purpose. Thirdly, the first wife, Srimati Lakshmi Devi, has not made any claim in this case, so she cannot provide any share by this court, being the first class legal heir. Fourthly, DW1, since so-and-so Devi is the mother of the deceased, she is entitled to get one share of the aforesaid of the debt security. Ultimately, this is the order, my lord, equally directed to provide share this whole amount among the four, not by depriving me. Here, my lord, my question is, my lord, my submission in this case, my lord, in the Exhibit 1, my marriage certificate, my lord. My marriage certificate
Considered to be legal.
my lord.
Your marriage is not considered as a legal marriage because in the substances of the first wife marriage, you got married.
My lord,
Therefore, your marriage is not legalized.
my lord, my special marriage
But yes,
certificate is
court
there, my
will
lord.
rightly
Same is
call
not
the
been
order.
objected, raised any question by the defendant, my lord. It is not question.
Friend, you are not the legal wife, legally married wife.
My lord, admittedly, from the evidence on record from the defendant's side also, she allowed with some other persons, my lord. Then my husband has got married with me, my lord. Then it is not possible for me to get,
Is there any divorce decree in that regard?
my lord. How could I get that divorce decree, my lord?
And
After
then
elopement,
there is no divorce decree
yes.
at all.
Now my question is,
The court rightly passed the order, allowed the petitioner.
then court
sharing
would have
the
court
three,
they-
four, all four.
my lord.
Your two.
Then,
children,
my lord,
they
insofar as
consider-
issue number 3 is concerned,
is cons-
issue number 3 is
considered-
concerned, court could have directed to the first to make the first party, first wife make party in this matter. First party, court would have directed to implicate the first party as first wife as a party in this matter. Then she'll come, she will object. Then the question would have been a different, my lord.
Why you are
But she has not been made party in this.
Why you are not made party?
That is the question, my lord.
Your duty was to make
Since court is appreciated me that I have not made party, court is appreciated issue number 3, my lord. Thus I have read, my lord. The court would have directed. My lord, Kali, this is very important, my lord.
No, it's okay.
Yeah. Issue number 3.
Case is not.
Court is satisfied, my lord. Court is satisfied that why I have that all the parties has been made parties in this matter, my lord. And my lord, since she is not party, how court can deprive me, my lord, that I'm not legally entitled this amount, my lord, by the trial court, my lord.
Is
Why
there any? That's why I'm. Is
Whole
there any
matter
divorce
that's all-
decree? Is there any divorce decree?
Well, from where could I get divorce decree, my lord? I'm the second wife. My husband,
Then-
after elopement of death, my husband
That's
married.
why
with-
your two sons and daughters who were there, they were considered
My lord,
and shares are given. to
my
them
my
also.
son and daughter will definitely get. They are not
yeah.
can eligible. My comments, my humble submission at this stage, my lord, since my lord court would have directed to make the party the first wife, then she come, then court would have decided yes whether. This is the question of whether she got in a divorce decree or not. These things I'm not aware of this case, my lord. This is
is
the
your
only
case.
knowledge of the
You could have
first
made-
party, first wife.
You could have made party to her.
So my humble
This is
submission,
your
then my lord,
case.
my matter may be closed. I may be allowed to direct it. This order may be lordship may interfere and directed to take necessary. Again, my lord, restart my succession case. I will make the party of the first wife. Then I will face the
No,
procedure, my lord.
Your case, this is not your case at all. It is case is doesn't. I mean,
Then is the duty of the learned
submitted
trial
and
court below.
closed.
Learned trial court. Why
You
learned
can
court has
dispose
not
it
directed to
right
make
now.
this party?
You can dispose it.
Since
right
with
now.
the first wife is the
It's a very good case to dismiss in fact.
no, my lord. Now, my lord, why court has
You
not
see.
directed to make the first party?
Directed. He has not made any claim there.
Right.
So that's why no claim is also given to her.
A whole dispute with the first party, first wife, my lord. Whole
Yes,
dispute the first wife. That she is the necessary party in this case. The court has appreciated me that yes, all the parties has made in
It is
party.
your case. Why you have not made party? to-
Other side has also not objected, you know, defendant has not done anything.
Why
Yes,
you
it's
have
not
made
necessary.
party?
My
Why you
lord,
have not paid because her daughter is there.
my lord,
So you could
sometimes in a title suit, in a trial court, my lord, it is also inadvertently supposed to fail to beg any party in this case. But it is on the duty of the defendant also. It is non-joint or necessity. This case is not maintainable. It is not raised by the
blame
defendants. my
the
lord.
court and the other defendants. You have
Lord-
not made party to her. You have not brought anything in this regard whether your
This is not-
legalized marriage.
My lord,
Yes,
this is
your
not
name
my
is nominee. You are not the nominee, but still the court considered you. I mean, your children is considered as a suppose they are also entitled, so equally divided.
My lord.
So
Please-
the two shares now. You think if it otherwise, if you think also 2 shares you are getting in the name of
Too
your
much
children,
children.
you are getting two shares.
Two children.
So, yeah, 2 shares you are getting.
No, no. Regarding my lord, my entitlement is a question different, my lord. Court has raised my bill, my legal, my lord, my marriage is concerned special marriage under Act. I married with my husband. How
This
could
is your fault. Your fault.
how
Without,
my lord,
without
I feel, my lord?
divorcing your first wife, you got married with the
My lord,
the
after elopement
person.
of my first wife, my lord, my husband, my lord has got
It's
married
your
with me.
case.
I don't
It's
know
your
that, my
fault.
lord.
It's your fault. It's not court's fault.
Then, my lord,
You got
whole
married.
question would have solved, my lord, had then
Mr.
I've been
PK,
allowed to make a party to
notice
the
going
first wife.
Mr. PK, the petition. Then video. Then appeal to 3. Yeah. Petitioner appeal advance set case. So and so. And section লিখি দিয়ক এইখিনি আৰু issue notice. Issue notice to both the response to speed post and material process also. What is I for?
I formed the stay of this order, my lord, because why? In the interim time, they disburse the whole amount, whole matter will be become infructuous, my lord. So for this purpose, my lord, I am, my lord. Let them appear, let them come, my lord.
Now what do you need now?
My lord,
2 shares you are getting. What do you need now?
my lord, Lanet
All
Lord,
the shares you
well,
need.
I'm not a,
What do you need? The mother
Lord,
should not get anything.
that's shall, my lord,
No,
actually
the mother should not get
of
anything.
course, my lord.
It's for you.
Of course, my lord.
And the
The
daughter,
entitlement,
she
the
has
author have been shared in 5 equal share, my lord. I am the wife, my 2 children, and
Two
their
children
my
you are getting
brother-in-law and
only.
first wife's daughter is there,
Children
my
you are
lord.
getting. You are not legally married wife and you are seeking the entire share
Regarding
now.
my,
Entire
my
share
lord,
now.
my legal marriage or not,
Right,
it is
very
not
right
in
also
dispute,
be
my lord.
passed by the learned trial court below. Hard লিখি দিব 41 or 41 একটু লিখি দিব state till next date state till next date.
My lord, in my, I am, my lord. I am, my lord. Notice issued, my lord.
Notice issue. No, yes, in I, yes. I এটা আছে notice issue. Okay. After chief. Hey, listen. Sharmila.
Your Lordship, Sir, in this case, my lord, we are agreed by an order, my lord, at page 61, dated
61.
61,
Ah.
dated 6/1/26, my lord. My lord, but fact of the case is that, my lord, in this, we are agreed by, as because, my lord, our plea that the decree was
It
obtained
was
by
a
fraud.
compromise decree.
It was a compromise decree, but we have said that decree was obtained by fraud, my lord, misrepresentation. But the learned court, the executing court did not entertain our petition, my lord. My lord, initially, my lord, the plaintiff, my lord, the respondent, filed a title suit for specific performance of contract.
The respondent.
A respondent. As per the respondent, my lord, she has given me an advance amount of rupees 7 lakhs 80,000, and remaining 5 lakhs 20,000 was to be paid, and the sale consideration was 13 lakhs. I appeared and filed written statement stating that actually no agreement was actually executed, no registered agreement was there, and her signature also was obtained in some papers when she obtained a loan from the said lady, my lord, the respondent. Thereafter, on 5/4, in this case also the respondent filed her evidence. In our written statement, we have categorically stated that while taking the loan, we have handed over the original land document. Why I'm saying I'm there. Now, my lord, I would like to draw your lordship attention to Annexure 5, my lord, page 37 to 47, my lord. 37 to 47. Now, this is the evidence on affidavit filed by the respondent, my lord. Now, only the
I'm
relevant.
asking, it is a case as per the decree, it is a compromise decree.
No, why I'm saying that this is obtained by fraud? That was why I'm pointing, my lord. Now, my lord, may kindly see page 46, my lord. Page 46. Exhibit number 2, my lord.
Yes.
Sale deed dated 21/12/10 in the name of defendant as regard the suit land. So, the original sale deed, my original sale deed, the land which the purchase document, my purchase document, the original sale deed is with them. And I have stated that this document was given when I obtained a loan from her. Actually, there was no agreement for sale with her. Now,
Why you obtained a loan from her?
the original sale was taken from me, my lord, by the respondent, who was the plaintiff in this.
No, why? You have taken loan.
I've taken loan. I've loaned for my medical purpose.
This is a mortgage document or what?
It was actually just handed over. The original document was handed over at the time of taking the loan only.
Why is there any procedure taking the loan you originally handed over? Otherwise, you could have, that means you mortgage your land or what?
It was not exactly.
Under what circumstances you've given all your original documents to her?
Exactly, my lord. What I'm stating, my lord. Here we have categorically stated that on.
So, and you're taking loan of a huge, what was this loan amount? Was it 13 lakhs?
No, not 13 lakhs, my lord. Actually, the loan amount was about, my lord, 4,50,000, my lord. We have stated in our written statement, my lord, that on different at page para 11, page 25, that the loan was actually 4,50,000 with interest, my lord. So when I obtained the loan, they took the original sale deed from me. And my signatures was also taken and check was also taken from me. Now, if I sell someone any land, whether I will pay any check or the person who is purchasing land from me will pay the check, my lord. If I am a seller, why I will hand over a check to the other party?
You brought those check in the court? Check you have exhibited?
No, check was not exhibited because before evidence, my lord, it was compromised.
So now, you are saying that you have delivered the check. Obviously, if you are the seller, it's not your duty to hand over the check.
Yes.
They'll give you the
They
check
will give,
amount.
but here
The question is, you have saying that I have taken loan, so I have given some checks to her.
Checks
So you
also,
have
and also
checks also.
And also original land document. On original land document also.
Checks are also not there. You have not exhibited those checks also.
No. It was submitted in the along with the written statement, my lord, the photostat copies. Photostat copies. The original were with in the possession of the plaintiff. So I cannot have that check with me because the original was already handed over to them. Now, my lord, on 5/4, my lord, I was called to before the court and was asked to sign a document, my lord. At that time, I was given the impression that this agreement has been done so that I may be given back the original deeds so that I can obtain loan from the bank and repay the loan amount with
There
interest.
was no advocate for you.
Now, that is why the advocate actually misguided her. Advocate misguided her and she
Oh,
signed the.
Now you are blaming the entire things to advocate.
No, we have stated in our petition also that on that day, my lord, there was husband was not with her, and she is not literate, my lord. She only can sign her can make a signature. Then, my lord, the exit.
I mean, there's a, you can file an FIR or the case against your advocate also, na?
No, that what they have done, I don't know, my lord.
You inquire.
Because that was
Such a thing, the advocate should be there.
yes.
Then-
Now she came to know that an execution she came to know only about this same when the execution proceeding was filed against her, and thereafter, madam, she engaged an other advocate, and then she filed a petition under section 47 of the CPC, saying that this decree was obtained by fraud, misrepresentation, and she also filed a petition that for allowing her to adduce evidence in this regard. Reduce her evidence. But that petition was rejected, my lord. Because, my
This
lord,
is the order at page 61.
yes, my lord. Because their judgment, my lord, which says that decree obtained by fraud can be challenged before the executing court also, my lord.
Can be there.
So that is our case that we challenge that decree on the ground that there was fraud and misrepresentation. But that was not allowed. And we have also filed a petition for allowing us to adduce evidence, my lord. But that was also rejected by the same order, my lord. In the Annexure 7 is our petition under section 47. And page number 59, my lord, is the petition we filed for allowing us to adduce evidence, my lord, in this regard. But that was not allowed, my lord. That is the problem, my lord.
So now you have received the notice, any?
After receiving the notice, we have filed this application, my lord. But that has been rejected, my lord, by this impugn order, my lord.
So as per the compromise, you were directed to execute the sale deed.
Execute the sale deed, and by receiving the, as part as compromise deed, my lord, interesting thing is that, my lord, I am required to pay her 15 lakhs, my lord. I'm coming to that. Page number 29, Annexure 3, my lord. As per this compromise the petition, I was required to pay her 15 lakhs, although the sale consideration only 13 lakhs, but I am required to pay her 15 lakhs within a period of 8 months, my lord. And if I do not pay her the 15 lakhs, then I will sell her the land for 5,40,000.
So there was an alternative remedy also. Alternative remedy was also given.
Alternative, don't know alternative remedy, my lord. Well, this is the petition, my lord, which was filed under order 23. Order 23, it was filed, and thereafter the decree was passed, my lord. So our case is that the decree was obtained by, my lord, fraud, misrepresentation, my lord.
Issue notice. What the advocate says now? What is his version now?
Now that advocate we have not made him, but we have engaged other
Meet him,
advocate.
you should meet.
We have engaged other advocate in this case, my lord. And In our petition, my lord, file under
If
Order
such
40.
fraud is committed by the advocate, then it should be. Instituted Consolidated 601 Federal and Civil Justice Senior Division. So execution case number 3. The sole respondents to speed post and then support for the scan copy of this. Next part, further considering this submission with the Mr. The further proceeding in execution case number 3 of 2025 pending before the Court of Civil Justice Senior Division Sonitpur Tejpur be stayed till next date. This the matter according to rules. Okay.
Abraham.
Any. Special mediation.
My lord, is a pay and recovery.
5, 6.
My lord,
Yes.
it's a pay and recovery matter, my lord. My lord, we have already paid to the claimant, my lord. And we have to recover from the owner, my lord. So these, my lord, type of matters are not, my lord, for mediation, my lord.
It was those these 3 are the for same
Yes,
pay and recover.
yes, pay and recovery.
So what is this says to one respondent number 1 has already appeared?
Prepared, my lord. And
You
we
are
have,
for the 1.
and
Is it
Your
three?
one is your you are the
I am the claimant.
claimant.
Yes.
2 and 3 yet to appear.
recently, my lord, 3 has appeared, my lord. For
Three
filing vocal number, my lord.
Pardon? 3 appeared, no?
My lordship. And since 3 has appeared in item number, my lord, 4, my lord,
Item number 4.
4, he can also appear in 5 and 6, my lord.
So in all 5 and 6 also he is item number sorry, respond number 3 only?
No, no, my lord. In respond, and item number 6, my lord, he's 7 and 8, my lord.
Your lordship, owner and driver are the same person. It is arising out of one accident,
Yes.
3 analogous cases. So driver and
Like-
owner number may vary, but they are the same person.
He have filed vocal number, my lord. It may go for hearing, my lord. File
In
hearing.
4 they are 3
Yes, ma'am.
in item number 4.
Yes.
Sorry, and item number 5
3, my lord.
in item
There are
number
5
5
also
also
3.
3,
And item number 6, my lord, 7 and 8.
7 and 8. Yes, they are owner and driver.
Owner and driver.
So what do you say? This is
Yeah, but
as
no-
per Mr. Burwa, it is
No,
may
your
not be a case
lordships,
for
they have challenged the
pay and
policy.
recovery.
Yes. So it cannot
May
be
not be a
compromised.
It will go for hearing, my lord. Notice has been
case.
served,
For
my lord.
hearing man, then can you tell us the what about 2 and in MSc 6? What about 3, 4? They have already entered into evidence or
Since owner has appeared, today he is, his filed vocal number, my lord, office note says, my lord,
in item number 4?
lordship. So he can appear in 5 and 6 also.
No, what about the other respondents?
In that case, all the respondents are represented. 3 is driver, isn't it? 3 is driver, he have filed wakalatnama.
Huh.
2 have filed today. So owner and driver is appearing.
2 is not appearing.
2 have filed wakalatnama.
3 has filed in item number 4, my lord.
3.
2 has not filed. Driver has not filed. So we can wait for service report, my lord.
The owner and driver, both owner and driver is to be there. Otherwise,
Drivers, well,
Driver's presence
driver
is not required.
may
Because
not be required, but
the owner has
owner is 3.
3, my lord.
Owner is 3.
Owner kanda basu, my lord.
And in item number 6, also there are 7 and
7,
8.
8, my lord.
Eight,
How-
eight,
Eight
my lord.
only.
Eight, my
eight,
lord.
last one.
And in item number 6, there are respondents. He is for the respondent number 1, I think. Claimant. No. In item number 6 also, you are the respondents.
I am claimant's respondent.
Oh, sorry, claimant respondent is in all 3 items.
In item number 6 is death case.
Dead case, my lord.
Death case, so there are many claimants.
Ah,
So I am representing 1 to 6. 7 and 8 are owner and driver and owner.
so 1 to 6 you are appearing.
Yes,
7 is the driver.
7 is the driver.
Strike out.
Yes.
Name?
8 is the owner.
Eight
Now
is the
owner, as per my learned friend's submission, owner has filed wakalat.
What number in item number
Number
4, my lord.
4.
So he can represent in item number 5 and 6.
5 and 6 also.
And in item number 5, how many respondents as a whole? 3.
3, my lord.
3.
So you are for the 1. 3 has already suppose owner, and 2 may not be necessary party.
My lord.
Can we strike out?
My lord, that I have to take instruction, my lord.
Take instruction
Yes, sir.
because
That's right. I have to take instruction.
there is a pay and
Recovery, my lord.
recovery because of the DL was not valid or something, or
It is
may-
not
may-
DL,
may-
but
may be reason.
ultimately court will appreciate the evidence of the trial court. Nothing new can be introduced.
But I have to take instruction, my lord.
And pecuniary liability is upon the owner. So if anything goes in their favor, it will be against the owner, not against the driver.
Not against the driver, but possibly driver has also taken some. There may be some.
My lord,
You take
I
instruction.
have to take instruction, my lord.
Okay, it's simply orderable past 5, 4, 5, and 6. Yeah. Item number. Heard Mr. B.K. Borba, the learned counsel for the appellate. And also heard Mr. D. Mondal, the learned counsel, appearing for the respondent number 1 in item number 4 and 5 in the MSc so and so. And respondent number 1 to 5 in
1 to 6.
1 to 6 in MSc 541 2012. Next part. It is also submitted by Mr. Borba that in item number 4 and Borba and as per office note also it reveals that in item number in MSc 542 2019 the owner has already filed his wakalat, who can also represent the owner in item number in MSc appeal number 536 and 541 respectively. 2019. Next part. This case was listed in the special. This case was identified for sending it through mediation. But considering the submission made by Learned Counsel for this, it is seen that the law point is involved. Basically, law point is involved in this case, and hence it may not be a fit case to send for mediation. Let the service be abated for the respond number 2 in item number 4 and 5 and respond number 7 for item number 6. Mr. Borba, the learned counsel for the appellant, will also take instructions. And it can be listed.
Your lordship, can it be, a date may be fixed in the month of March.
Yes, my lord.
Within 1 month, they can took instruction.
My date will be
So in the second week of March, it may be 9 or 11.
Now 11 mean 19th of March will.
Oh, no.
Obliged.
Number 7.
May I please, your lordship? This matter may be placed before the mediation, your lordship.
It can be. Seen.
It can-
Item number 6. No, Mr. Neog, na?
B. Borgo, High Lordship.
B. Borgo. Oh, sorry. Heard Mr. B. Borgo, the learned counsel for the appellant. Heard Mr. T. Kalita, the learned counsel for the respondent number 3. Is identified for sending it to mediation and is submitted by the learned counsel. That matter may be sent for mediation and probability is also there for settlement. In view of this, that the notice to apply for raised that the notice be issued to the both appellants as well as the respondents. Registry will put in it. And matter may be sent for mediation. Fixed করে দিবেন তাতে একটা date fix করে দেয়া হবে। In preferable date, any date in the month of March, or maybe at the end of February also, we are not fixed. February can be 26th of February.
For mediation, my lord.
For mediation, notice will go, and you also take can inform your party also. That the 6th of February, so and so, the learned High Court Legal Services Authority will take necessary steps in appointing the mediator and fixing the date and appointing the mediator in that list. We're listing it on 26 too, and the mediator will be appointed accordingly by the state legal service.
Much.
Sorry, High Court Legal Service.
May I please, lordship?
Yes,
Lordship,
here this can be
lordship, in this case, the registry note shows that, lordship, notice sent to the respondent number 1 and 2 has been received back.
received back.
But in this case, lordship, some mistakes are there. At flag X, lordship, kindly see the flag X.
Back X.
Our appeal is at MSC appeal number 159 of 2025. But at flag X, lordship, one record has been attached in respect of appeal number 169 of 25. Our appeal is 159 of 25. Apart from that, advocate for the respondent number 1, that is insurance company has been appeared, called stored. So notice upon you are appearing for
Flag X.
One and two.
The number is, I can understand, number is 169, your one is 159.
I am for
But
your
the name and address is same,
party is different.
party is also different.
Different.
Oh, I don't guess.
Documents relating to 169 and be attached with this record.
RT and R4 has been.
Our party's name is Niroda Thakur and others, but here appellant is
We to put it 169 or logai dile. Oh, actually the entire office note is of 169.
Lord.
Oh,
but he is appearing for respondent number 1 and 2.
oh, no, like you say no. But anyway, you are appearing for
Respondent number 1 and 2, my lord.
in MSC appeal number 169.
Yes, my lord. Actually, I'm filling in for a colleague, my lord. He could not make it today. That is why he asked me to take his place for this representation.
And respondent number 3 and 4 is also same party lordship. Advocate for the respondent number 3 also appeared, falsely showed. He is appearing for respondent number 1 and 2. So the particular lordship notice may be.
You are appearing for whom? In fact, respondent number 1 is Srimati Niroda Thakuria, and
I am for Niroda Thakuria. Appellant.
ICICI.
sorry, you're for the appellant. Sorry.
Yes,
See, ICICI
yes, my lord.
and 2. Okay. Now you are appearing for 3.
3
and 4 here, to
and
Dharmaram Deka. So they are appearing though.
Lordship, service complete, but wrongly lordship that documents is attached with this case record lord. Which is keep as a flag X. That's relating to appeal number 169, not for my appeal lordship.
Yes.
So that's why the office note has to be corrected. Since they are appearing lord.
Otherwise, as per the, they
Otherwise,
have
lord,
already
service
appeared
complete, service complete. Lord.
And what about your say if the case is sent for mediation?
Lordship,
We'll make correction. Otherwise, I'm just asking.
one time Lordship may be sent, but I do not Lordship find that their matter would be solved, dear Lordship. That's because here some question of law is involved, Lordship.
No, you're for the enhancement or what?
Lordship, in
For
this case,
enhancement only?
only one point, Lordship. Dijesh was the government serviceman, Lordship. But at the time of Lordship counting his income, his income has been Lordship has been taken under the minimum wages, not taken from his actual income. Although his salary certificate and Lordship admit
He was not a government servant.
government servant.
Government servant.
Government servant. He was Lordship doing 31,500 Lordship, but his income has been calculated as 7,000 under the minimum wages.
What?
Lordship, only point that Lordship, person from the office was not examined, Lordship. Although his salary certificate was Lordship exhibited in the
Salary for the late certificate. Anyway, okay. You are Mr. P. Sharma.
Settle the matter.
You are Mr. You are Mr. who?
M. Hazarika, my lord.
M. Hassan.
Hazarika, my lord.
M. Hazarika appearing
On behalf of AG Sulkia, my lord.
on behalf of A. J. Saikia for the response number 2, 1 and 2.
Yes, my lord.
And you are MS
And Goswami.
and Goswami appearing for the response number 3 and 4. As it is seen that the services already completed in this case, and case was also identified as a for send it for mediation. But submission, considering the submission made by learning counsel for the appellant, it is seen that the office note and the flag X which has been annexed along with which has been tagged along with the petition is pertaining to MSc appeal number 169 of the 2020 and not in connection with the present case. In view of this, the registry is hereby directed to verify and correct the office note and also to annex the proper and the correct record along with the present appeal. Present list. So for this anomaly, the matter also could not be sent for mediation. Registry is accordingly directed to collect the same and list when it can be listed now. Of February will list.
Can it be 26th?
26.
26th.
Okay, we'll list.
May it please your lordship.
Now, my lord, the petitioner was arrested on 13/11/2024. Total number of days as on date is 1 year, 2 months, and 20 days. The total number of witnesses is 9, out of which till date, not even a single witness has been examined.
Charges framed already.
Charge was framed on 30/7/2025. Now, my lord, there were 4 accused persons initially. Out of 4 accused persons, 1 expired in custody, 2 were granted bail, and she is the last one. Now, my lord, my grounds are that the grounds of arrest were not communicated in the language the accused understands, and I'll demonstrate it from the notice issued under section 47. This is 1. Second, absolute non-compliance of section 48. None of the family members were given any intimation whatsoever. And that also I'll demonstrate from the records. Now, my lord, may kindly take up the section 47 notice to start with. Your lordship will find at page number 31.
Lordship, I'm sorry for interrupting, Lordship. The records, Lordship, the CD part is the entries of the CDs are not in the scan copy. By the last order, Lordship had called for the scan copy of the case diary. It has not been received, Lordship. There is an office note. That will be
Received.
That has not been received, Lordship. That will be required, Lordship, because regarding 47 and 48, we have to go to the entries because whether it was communicated to in the language she understands, all that will come only from the entries of the case diary. So that will be necessary, Lordship.
My lord, on the last occasion, my lord, when this matter was called up, because of, if your lordship remembers, because of the traffic jam, because of Ganesh Puja, at the 11th hour I came, the same submission was made, and I did not have the opportunity to go through the records on that day. But after the item was over, with the permission of this court, I verified the record. My lord, with all respect and all humility, perhaps my learned friend has not gone through the records. These all are there in the records. I have flag marked it. 47 notices there in the record. I have flag marked it. 48 notices are there in the record. I have flag marked it. These all records, already the court below have remitted to this court. I have categorically flag marked with.
No, just Mr. Biswal. What he has submitted is not that.
Yes.
He has submitted is something else. Just listen to him.
He
What
is,
he has submitted.
he is saying that there will be some entries in the case diary which will show as to in what language it has been communicated. My lord, once the notice itself is before the court, the primary evidence is before the court, how the entries will help? Once the 48 notices, vacant 48 notices are before this court, the primary evidence are before this court.
Your petitioner understands which kind of language?
Assamese.
She understands
As
Assamese.
she has Assamese, she has put her thumb impression, page number 31. It is in
From
English.
She has from which?
Assam, Bilashipara. And I can also show one, that printout that today morning. I'll just.
Yes, just a second. What to do? Yes, obviously he is submitted correctly because scan copy was called for. Now, otherwise the 47, 48 are there in the case record.
Yes.
Because at the time
Yes, that is
of the producing the
Yes.
accused, those are there. So it's already there. So you need you need the case diary or what?
Yes, Lord, in my respectful submission, it will be necessary, Lordship, because if Lordship sees the 47 also, she has put her right thumb impression. But whether this notice was made to her understand in her language or not, whether it was read over to her, Lordship, that will be only clear from the case diary, Lordship. And also 48, Lordship, it was sent via WT message to the concerned local jurisdiction court, police station. So, Lordship, whether that compliance is there or not, Lordship, that we have to see from the case diary. Only that much, Lordship.
But now see, this order was passed on 22nd of January.
Yes.
So now we are on 2nd of February.
Yes.
That means suppose 8-10 days gone.
Yes.
So why restrict you anibo prana scan copy of the case diary ami beside. No, notice already there. 29 of them.
Yes.
Because of so vacation or any. Date of
My lord, with all respect, my lord, subject to what your lordship says, my lord. Assuming for a moment, the case diary says that it was explained to her in Assamese language. Will it suffice, my lord? The prima facie, the notice itself, there is no mention, and it is in the notice where her thumb impression appears. So this will hold her responsible, not some obscure entry by some police officer at some point of time, maybe midnight, maybe in his own police station. In my whatever little I understand, my lord, because my client can be held with this document. There is nothing in this document. I will just will bear with me for 10 seconds, my lord. I'll show it to Divasum, Dada. Just recently, My lord, will see. This is a man from Bihar. He was arrested in Nagaland. My lord, in Nagaland, very rarely people read and write Hindi, unlike Arunachal. Very rarely. Even then, your lordship will see this section 47 notice is in Hindi. This is true compliance. That is what Supreme Court says. This is true compliance. Just formality sake, I'll say some section, big words, narcotics, psychotropic substance, and will take some lady's fingerprint, and I'll say 1 year, 3 months, and I'm taking, because notice of motion in this case was issued on 17th of December 2025. More than 40 days elapsed. If at all there was some compliance, they could have easily obtained certified copy, because at the end of the day, my lord, whatever little I understand, my lord, it is the fundamental right of a lady which is at stake. That is what I have read from the judgments, my lord. I may be wrong, I may be right. That is what I have read and I have understood, and the counsel I am submitting before the court. The very notice demonstrates that it is not being explained to her in the language she understands. Number one, the 48 notices are not with me. I made a categorical statement in my bail petition that there is that there was total non-compliance of 48 notice. 40 days elapsed. No objection, no affidavit saying it is being complied with has been filed. Every time, my lord, some new grounds are taken just to delay the process, my lord. And in the record, I have checked, my lord, 48 notices are there. These are blank 48 notices. This is addressed to none. If your lordship just, for my sake, if your lordship just turns to that LCR, I have flag marked those. Your lordship may kindly see these. There are 348 notices to 3 different accused persons. It is blank. To whom? No address. Blank 48 notices. I inquired not twice, not thrice. I told my client categorically, if tomorrow 48 notice comes up, I will not come to your rescue. They assured me, sir, and that's how I made this statement on oath, and that has been corroborated by the records. That's my humble submission, my lord. And moreover, my lord, the other 2 accused has already been enlarged on bail.
Pardon, sir. As per order dated 22/01/26, the registry was directed to court the scan copy of the case diary as was not available along with the scan copy of the case diary. But from the office note dated 29/01/26, it is seen that scan copy of the case diary is not yet received by the registry. In view of this, registry hereby directed to issue reminder immediately. Reminder to the the concerned court to send the scan copy of the case diary on or before short date 550 6 6 can it be? But it's not your
Yeah, he cannot.
But again,
He
Lordship,
cannot say.
if it doesn't come, Lordship, again there will be approval.
Six, I don't know, it will be rich or
Even I have my serious doubts regarding.
uh,
Though it is at a handshake distance, it is the other. It's from Kamrup Metro.
no. Kamrup
Yes,
Metro.
yes.
Is it from Kamrup Metro?
Yes.
Oh, acha. I thought you were saying that
Bilashipara is the ladies from Bilashipara.
She is from Bilashipara.
His original place is Bilashipara.
Otherwise, it's Kamrup.
Kamrup Metro, handshake
Oh, if
distance.
it's Kamrup Metro, then we may take a chance on 6th. Read evening. 6th. Okay. And you go to the record. And if but that may not be possible on your part because already case is charged.
Yeah.
IO it cannot be received.
Yeah.
So everything will be available in the case diary itself. If you need anything from the case diary. Otherwise, Mr. Biswas is submitting that there is a blank in 48.
Lordship,
There's
to be on the safer side, Lordship, subject to your Lordship's
Nine.
convenience, let it be on 9.
Maybe on 9th. I also think so.
Oh, 9th,
Mr.
I'm in
Biswas-
9th, I'm in Itanagar. So 9th,
Will be not Jan-
9th, I'm in Itanagar. 9th, sorry.
We are going to stay there in Itana. Oh, so
The
9th.
matter is
Matter
fixed on
is
9th.
Okay.
So 6th, let us take a chance on 6th. Or 10th would be safer. Subject to your lordship
Let me-
availability at the
I
principal jam.
was thinking of it the 6th, but I also think that may not. There's the issue.
But today is
be
Monday,
10th.
today is 2. So if the requisition goes today, 6th it will come. Because 4 days are sufficient from Kamrup Metro to here. 6th it will come. Because
Okay.
already
Well,
requisition
still
has gone.
sixth. Okay.
Ah,
আপনি একটা
I'm
খবর
deeply
করে
aware.
দিব আজকে আজকে ফোনকালে অর্ডার করে দিব আজকে ওকে
I'm-
we're listing it.
I'm deeply aware.
19 Lordship, there is a office note warrant. PCR not received.
I have dealt with this case in
Yes,
3-4
but- yes,
occasions,
first time,
so I'm
first
just a little bit, it is there with me, knowledge. But
Right.
as per the last order, most probably there are
Yes.
some 2-3 witnesses which may be
Yes.
considered as a
Yes,
vital. Those
yes.
were already
Yes.
examined.
Examined, my lord, some of them have
Issues
been
that they have raised, the issues they have raised, I think the TCR is not available today. TCR was called for on last occasion, on 29th, when the matter was fixed, on 8/1/2026. Office note was on 29/1/2026. The CCR was not here before the court. I think the contentions
Now,
that they have raised,
have you filed the certified copies?
Yes, madam.
and
The certified copies of the last witnesses? Those
Yes,
who have
yes,
been
yes, yes,
examined?
yes,
this
yes.
is the.
Certified copies are here, madam.
and
I have
this
an,
is-
I have
I
an
have
ex, madam.
already-
I have an ex.
And this is the compliance report which a duty is cast upon the public prosecutor to notify the informant. And accordingly, the IO was notified. IO in turn notified the informant
Hmm.
that a case has been pending for bail application. And accordingly, today, 30th January of 2026 was fixed for bail hearing. So he was notified that time impression was taken from him. That is the compliance report.
So the informant is already.
Informant was notified. So I think at this
And
stage,
this has
amicus
to be
can be appointed for this case, and the TCR, a reminder can be issued at this stage because the TCR was called. Scan copy of the TCR.
So as a whole, how many days your petitioner is in custody now?
That is almost more than 4 years, my lord, now.
He was arrested on 36,
2020.
2020.
No, because
Yes,
I can understand the last order as per.
Yes, yes,
Sir,
yes,
there
Yes,
are
yes.
only your lordship.
4 witnesses I have identified.
Five
apart from
Yes,
your
I have
submission. of-
I have submitted a list of 14
List of
witnesses.
14
List
witnesses.
of 14. One
Out of
witness,
which, yes.
only one witness remained. The other
Others-
witnesses were examined.
That's why I'm just asking whether those were examined or not.
Absolutely, that were examined. That were examined, and we could have examined because on last 3 occasions, that is on 25/11, 29/11, another day I forgot. Those are the dates where the presiding officer was absent because at that point of time he was on leave.
Oh,
So that is why we could not examine that particular witness.
this case is from Guwahati itself?
No, Dorong.
Dorong, no?
Dorong district.
Dorong.
It's a POXO case.
Fox.
So may I humbly pray at this stage to fix up on 27th February, subject to the convenience of the court as well as the learned counsel,
What Mr.
27
Pines-
February is
because the TCR has to come.
No, my lord, this year, if your lordship call for it this year, can it be fixed on 9th or 10th?
9th or 10th probability.
I don't
yeah,
have any objection, but from Dorong, just I am
Uh,
just apprehending this.
just don't take chance on 9th and 10th.
My
Yes.
lord, as my learned friend earlier, my lord has submitted, it is matter of fundamental right of a person.
No, obviously, we are not.
That's why, my lord.
I'm just saying
That's why,
that
my lord.
suppose if
Yes.
not it reach,
Because
if it is reaches by this 9th or 10th,
Yes.
it's okay, but
second
some-
second
That is
week
what-
of February is good enough, my lord, but
second.
last week of February, my
Now
lord,
it's okay. Like the 2nd of February, 9 not
Second
or
of February,
when
before 17, I will seek, my lord.
16th, I have a case. 15th, the date will clash. Let it come up on 18th.
No, but from
17,
17 onwards, 17, my lord, I'll be very busy.
Then 25,
No.
25,
15 can be 1/5.
15th is the Sunday.
Oh, sorry.
It is Sunday. Let
15.
it be on 18th, 26.
16 Monday. Can it be on 16 or 16? Let it be on 18, my lord. then.
18.
In that case, 18.
Yes.
18.
So we are going to appoint the amicus today.
Yes.
Heard Mr. J. Pine, the learned counsel for the petitioner. Heard Mr. Hassan. You're Hassan, Mr. Hassan.
Yes.
Yes.
Special PP here in this
Yes.
case.
Specific.
Special PP for the state respondent. Uh, Mr. Hassan has also submitted the compliance report in regards to the notice issued for the informant respondent. However, no one has represented the informant respondent. That is accordingly, let the amicus be appointed to represent the informant respondent. S-
Otherwise, I have annexed my lord prosecute PW 34 onward,
Oh, yes.
your lordship that.
Mr. Esdas, Surudidas, as an amicus for the respondent to applicant. Distributing, providing. Further from the office note, is seen that the scanned copy of the TCR has not yet been received. The registry will do the needful in issuing reminder. The matter be accordingly listed on, you're saying 18th, na? 18th. Sorry. And do one thing, Mr. Pai, we are calling for the case diary, but in spite of, if you get the certified copy and the present status report to call for the present status report, you just
Yes.
furnish before us.
Certain.
That will also
That
suffice.
will also, sir.
We're listing it on otherwise on it.
Available.
For addition, item number 13.
That's how it would be.
May please, your lordship. Lordship, inadvertently, this petition has been filed under Article 227.
May I please have it? Lordship.
Just a second, yes, then.
It ought to have been filed under Order 43 Rule 1R. Appeal will
Appeal.
lie, your lordship. So
Oh.
I may be allowed to withdraw within liberty to file appropriate application under Order 43 Rule 1.
In that case, do you want to say anything? Because he is seeking the liberty also, saying that inadvertently it was filed under 227.
Matter may be taken,
It have been filed under 43.
matter may be taken after few times because senior, the engaged counsel as Das is another. So
After some time,
after some, I
you have done
can go to the,
or after some time.
Lordship.
Otherwise, I'm.
Yes,
I
and
don't want anything
our
to
High Court
do-
judgment is also there, your
Yes,
lordship.
it's
Yes,
there.
yes.
But he is most probably not in a
Lo-
position to
Lordship,
say anything,
Lord-
so let after some.
Lordship.
Okay.
may it please, your lordship. Lordship, this is a transfer petition, my lord.
You have not taken steps for the response.
No, we have taken steps. It has been received by the partnership concern, the employee of a partnership concern.
Hmm.
And it has been deemed to be served,
Deemed to be served by which order?
my lord. My lord, most probably 7/4/2020.
7 court.
And subsequent to that, the proceeding of the learned trial court has also been stayed. But that has been also informed to the learned trial court. The parties have appeared there, the opposite party respondent here.
They have already appeared
They
there.
have appeared there, they are in the knowledge that this is pending. But after that also, they have not appeared.
It's a case against any,
There's a money suit, my lord. Respondent
suit,
had
okay.
filed a money suit claiming a certain
now
amount.
presently case is pending in which court?
Civil Judge Junior Division number 1, Kamrup Metro.
And then from where you want to?
I am praying for transfer to Sunitpur because the reasons are that, my lord, I am a low income person and I have liabilities with regard to my old aged mother whom I cannot leave to come here, and I am having
But where-
certain,
These are the grounds under 24.
yes,
Where
my lord, but I have also,
yes, as much no such ground for section 24. These are not the grounds, I think, for transfer.
And I'm
Because
having
if there
met,
is a jurisdictional issue or the cause of action, this kind of considered, this can be matter will be considered.
yes,
But for your financial things,
financial and as well as medical, my lord, but
may not be a case under 24. Anyway,
my lord, this
can be, is there any, but I don't want to reflect it here in this case, order. But as you have submitted that they have already appeared there in the, before the trial court. So if it is possible, can it be informed to stay, matter has already been stayed there? Or is order of stay also
order has
was
been communicated. I have,
communicated, with that communication only whether the learned trial court below had also passed any order
my lord,
regarding
I
the stay?
I'll have to get the instruction because I'm not there to
Because
counsel.
why I'm saying that you are saying that he, the company or association, whatever, they have already appeared before the learned trial court below.
Yes.
So it may be within their knowledge also, if their stay order is there.
Yes.
So when the next date is fixed, can you tell us anything? If it is already stayed, then it's okay. Otherwise, when is the next date?
And I have to check up. I'll take the instruction because I'm not the engaged counsel there.
Oh, watch it.
This is a legal aid matter.
Legal aid matter. So legal aid counsel is there. Otherwise, you are appearing as a legal aid counsel here.
Yes, yes, yes. I'm the legal aid.
You were already appointed as a legal aid counsel.
Yes.
Please just take the instructions in that.
Yes.
We are just passing any order. Just next week we are listing it on next week.
Yes.
Want any fixed date here or after 1 week? It will do.
After 1 week.
After 1 week. Considering the submission by Mr. The done it legal aid counsel, let the matter be listed after 1 week. As soon as it will be take 2-3 instructions whether the case date of listing and whether information is already they have received the information. In that case, we can pass the order because the reasons for the grounds for the transfer may not be sufficient for section 24. That's what I'm saying. That's why let's
The interim may be.
interim was there. Oh yes, interim be continued till next. Stay was there.
Applied.
Oh, নামি ল'ব পাৰিলো কোনটো লাগে 13? Oh, আচ্ছা আচ্ছা oh you have so
If they want to withdraw,
মানে it was inadvertently under 227 in
Yes.
43 na?
43 one. Appeal will maintain.
Yes, yes.
Appealable order, not.
No, because I'm just because he is seeking a liberty also. That's why that's I'm asking. It's okay then. Hard Mr. AJ Coach, to Mati Divo.
Heirs from Lord.
Oh, sorry, heirs from the learned the petition. Super Mr. Esdras, the learned counsel appealing respondents. It is submitted by Mr. Shown that inadvertently the present petition has been filed under Article 27 of Constitution of India, read with Section 115 of CPC, though it ought to have been filed under Order 3, or as it is a case of a matter of agreement. Accordingly, he submitted that he may be allowed to withdraw the present petition within the 5 fresh with same prior to which does the learned counsel raise objection. Matter is accordingly be withdrawn with deliberate and fresh in proper order of exceptions.
Probably, my lord, it may go to the district judge.
Oh,
Jurisdiction is.
If pecuniary jurisdiction is.
Less,
Prior
your lordship.
jurisdiction is how much your jurisdiction?
Less, your lordship.
Oh, then so it may go.
It may go, your lordship.
So yes, it's good option. You take withdraw this case and then file it.
Only 75,000.
Then it will go.
Oh, then it will go.
Lordship.
Ah,
Lord.
75,000.
Definitely.
File it before district judge. Okay,
Lordship.
so rightly you have withdrawn. Yes, it file it.
Lordship, the period of pending this, that may be excluded, lordship, and observation may be.
That will automatically
Lordship.
dispose.
Liberty
Yes,
Lordship
yes,
given.
liberty I have already.
Oblige your Lordship.
That's why it is.
Yes.
Informed by them that they want to take time today.
Yes.
So,
You want to take time. But Mr. S. still done it for the petition. Also heard MS. You are
R. Shah, correspondent number 8 to 17.
the every council appearing for the respondent number 8 to 7. And what about the other respondent? Is there
Expertise, my lord. Service
others are
completed.
expert, service company?
Service completed.
You as well as considering this submission made by Mr. Das. It is in the services already completed. And listing how many weeks, any date,
After 1 week, my lord. Because all
one. Want any fixed date may not be possible. That's why I'm asking.
yes, just after
Fix-
1 week.
after 1 week.
After one.
This time considering this submission, so and so. After adjournment, they have become not there. Just accordingly, after 1 week, isn't it? Okay.
My lord. Highly approved.
Sir, maybe possible for the time being worksheet.
Time being.
Lot.
Otherwise, here, you are appearing for the respondents. How many respondents? Sole respondents, or how many
Sole-
respondents
sole.
are there?
What?
You are appearing for whom?
Respondent number one.
How many?
Anjara Begum. Anjara Begum.
No, Amdara is okay. But additional affidavit to be filed by. We have already filed your additional affidavit also. Okay, for timing.
This appeal has been basically filed on the ground that the claimant is the wife of the deceased and she is also pension holder. Page 17, middle portion. During cross-examination, she has admitted that she is receiving pension of rupees 29,000. Page 17. And husband also retired person, he is receiving 27,000 as a pension. Lordship will find.
No, who died? Her son?
Husband died. Page 24. Monthly pension of rupees 23,476, para 39.
My lord, I am appearing to the caveat, my lord.
In this particular case, Lordship, we have challenged on the ground of Lordship, the multiplier should be 5 and she should get 50% of the pension, but whole amount has been considered for assessment of loss of dependence. So appeal may be admitted, we will deposit 50% and subject to deposit, stay may be granted. And already my learned friend has appeared as a caveat for the claimant.
You are for the claimant respondent.
My lord, I have filed caveat, my lord. My name has not been shown.
My name also not shown in the cause list.
So you are for one or one?
One, my lord.
2 and 3 are there, no? Still?
Lordship, 2 and 3 will take steps by registered post.
My lord will take call for the record also. It's from Kamrup, my lord. Metro.
Meeting on it, counsel for the applicant appellant. Mr. H. does still on it, counsel appearing for the caveat approval report, appearing for the respondent number 1 of the caveat. This is an appeal. Under section 173 MV Act against the judgment and order date 26/06/2025. A very learned member MSCT. Number 2 in Kamrup M, Guwahati. In MSC case number 2054 of 2020. Matter is accordingly admitted. Hearing. Issue notice to all the respondents.
No, this to respondent number 2 and 3 by usual process.
Only you want to take usual process.
Usual process, then better also. Court process will better also.
Usual process to the respondents. No formal notice is required to be served on respondent number 1. Copy of the memo copy may be served during the course of also call for a TCR. Let the matter be accordingly listed. Weeks, definitely. Give it to the judge. Out, I
50% deposit.
50% you are going to
50% will deposit before the registry within 6 weeks.
regarding withdrawal. Do you want to say anything regarding withdrawal?
Withdrawal looks it
Subject to bond, my lord,
subject to
as
bond.
usual, my lord.
Subject to bond, it may be released.
Submit if I'm also which does the to the claimant response. Nam karon an application state judgment and dated 26/06/2025 filed by the learned member MSc number 2 in Kapro Guwahati in MSc case number 2054 of it. It is submitted by Mr. Kusami that the applicant is ready to deposit 50% of the awarded amount subject to stay of the further subject to the execution of the award dated 26/06. Considering the submission made by Swens, let the judgment and award dated Swens as well under the Swens be stayed till disposal of the connected appeal subject to payment of 50% of the awarded amount within 6. Next part, further, the registry is hereby directed to disburse the deposited amount to the respondent claimant after due and proper verification and subject to on condition of submitting execution. You can execute a bond. In that regard, we are going to disburse after due and proper verification.
On proper identification.
My lord,
Obliged.
some time limit has been given.
6 weeks. 6 weeks has already been.
In fact,
I
my lord, next date, my lord.
after 4 weeks.
So, if registry may direct it to store the name of the
Oh,
applicant.
sorry.
advocate
Yes,
as
the
well as
registry is
name of-
hereby directed to reflect the name of Mr. Swenson in the cost is on the next step. We are listing.
My lord, my name also.
Yes, just directed. Yes.
May I please your lordship? The appeal is against concurrent findings. Lordship.
Concurrent findings.
Yes, lordship. I was a plaintiff before a trial court.
You were the plaintiff.
Yes. My plain and simple case was that my mother, Nazmiara, he married with Abdul Motin, second wife of Abdul Motin. My mother
Your
was
mother was the second wife.
second wife of Abdul Motin. And out of Abdul Motin and Nazmiara, I born on 3/2/1994. So I born, but after my birth, divorce was taken place between Abdul Motin and my mother on 3/2/1994 as per Mohammedan Sharia. And out of their wedlock, I was born. So the defendant respondent was the first wife, number 1, was the first wife of Abdul Motin, and defendant number 2 was the daughter of Abdul Motin, and number 3 was the son of Abdul Motin. So I have filed the suit against first wife of Abdul Motin and his daughters and daughter and son,
and daughter,
seeking a declaration that I am the daughter of Abdul Motin. Secondly, being the daughter, I was entitled for the pensionary benefit of late Abdul Motin, as because Abdul Motin was a government servant. So the written statement was filed by the present respondents. Subsequent to that, they had not contested.
Accordingly, I adduced my evidence, but the learned trial court by judgment and decree dated 3/2/2016, the suit was dismissed. And title appeal was also dismissed on 5/4/2018 against the present appeal has preferred by the present appellant, Your Honor, appellant plaintiff. During the trial, Your Honor, I had exhibited my birth certificate, wherein Abdul Motin was shown as my father. And the Kabinama, which was executed amongst Abdul Motin and my mother, as because the marriage was solemnized as per Sharia laws. But the exhibit 1, that is my birth certificate in original, as well as the Kabinama, those were not considered by the trial court, saying that the same were not proved as per law. It was my duty to call for the officials to prove those documents. Kindly see the findings, Lordship, of the learned appellate court. Is at page 28 of the memo of appeal. Decision of issue number 2, whether plaintiff is the daughter of late Abdul Motin. The plaintiff, in support of her contention, examined 3 witnesses, including herself. PW1, who is the plaintiff of the suit, in her examination, it stated that her father Abdul Mojid during his lifetime married 2 wives, namely Nafisa Mumtaz, defendant number 1, and Musammad Nazmiara. Abdul Motin married Nazmiara in the year 1990. She stated that after divorce between her father Abdul Motin and her mother Nazmiara, she was left at her father's house and was taken care by grandmother, namely Musammad Sofia Bewa, wife of late Abdul Karim. Exhibit 1 is the birth certificate of plaintiff Subnam Yasmin. Exhibit 2 is the Kabilnama of marriage between plaintiff's mother and father, and exhibit 3 is the photographs of plaintiff's parents. PW2 Al Mubarak Hussain, in his evidence, stated that plaintiff is the daughter of late Abdul Motin, who died on 5/11/2011, leaving behind him plaintiff Nafisa Mumtaz, defendant number 1, Nazmin Sultan, defendant number 2, and Parviz Sajad, defendant number 3. He also stated that Abdul Motin during his lifetime married 2 wives, namely Nafisa Mumtaz and Nazmiora. Abdul Motin married Nazmiora in the year 1990. PW3 Sarifa Bewa, wife of late Abdul Motin, in her evidence stated that Abdul Motin married Nazmiora in the year 1990 and he divorced Nazmiora on 3/2/1994 as per Islamic Sharia. Therefore, Nazmiora left her matrimonial house, leaving the plaintiff in her father's house, so the plaintiff was being looked after by her grandmother, namely Safia Bewa. But after the death of Abdul Motin on 5/11/2011, nobody looked after the plaintiff. She also stated that plaintiff is an unmarried daughter of Abdul Motin. Paragraph number 16, Lordship. Now, looking back to the evidences of PWs, it appears that the plaintiff pleaded that Abdul Motin married Nazmiora, but said Nazmiora has not been examined in the case as her evidence. It is necessary to appreciate and judge the version of plaintiff. The learned counsel for the appellant during his argument submitted that said Nazmiora Begum, after her divorce, she left her matrimonial house and got remarried with another person. It is worth relevant to note that none of the PWs in their evidence stated that said Nazmiora is no more. So in such situation, non-examination of Nazmiora casts doubt in plaintiff's case, because it is Nazmiora Begum who can better say about her marriage before Qazi. However, the plaintiff wants to prove the marriage of her mother with Abdul Motin by the exhibit number 2, that is the Kabinama. I have scrutinized the Kabinama construction of which appears to me as copy of original Kabinama. Now, it is to be then law requires that it must be proved by production of original register of Kabinnama by official or Qazi of the Office of Registrar Muslim Marriage and Divorce, Jaleshwar, Gwalpara. But neither Qazi nor any such official has been examined to prove the content and entry of the copy of Kabinnama with original register of Kabinnama. It is relevant to note that mere marking of documents in evidence is not sufficient. The contents to be proved and its genuineness, validity, and enforcement with the meaning of Section 3 of Evidence Act. Paragraph number 18, Lordship. It is further relevant to note that neither PW2 nor PW3 in their evidence stated that they were present in the office of Qazi at the time of marriage between Nazmiara Begum and Abdul Motin. Moreover, from Exhibit 2, it appears that Hafiz Uddin Ahmed and Zahirul Islam were happened to be witness of the marriage before a register Muslim Marriage and Divorce, Jaleshwar, Gwalpara, Assam. But the plaintiff withheld from examining those two witnesses to prove the marriage between Nazmiara Begum and Abdul Motin. Paragraph number 19. So far, birth certificate of the plaintiff, that is exhibit, is concerned, same is the situation appears here because plaintiff has failed to examine officials from whose office the birth certificate was issued in order to prove the fact and or contents of birth certificate. Further, the original register which carries the fact of born of plaintiff and the person informed about the birth of plaintiff or the source of born of plaintiff, that is hospital record, etc., has not been produced in the case to prove those facts and entry. So, mere production and marking of birth certificate cannot be said to be exclusive proof of the fact that the plaintiff is the daughter of Abdul Motin and Nazmiara Begum.
So, what is your have you framed any substantial question of law here?
Yes, Lordship.
Where?
Yes.
Where, in which page?
First page of my memo, Lordship. First page.
Yes.
Lordship,
So these two.
primarily, number one, Lordship, whether the learned court below erred in law in not considering the birth certificate exhibit 1 of the appellant plaintiff as a public document under section 35 and 77 of Evidence Act. 35 of Evidence Act, Lordship, says relevancy of entry in public record or an electronic record made in performance of duty, and entry in any public or other official book, register or record or an electronic record stating the fact in issue or relevant fact and made by public servant in the discharge of his official duty or by any other person in performance of a duty specifically enjoined by law of the country in which such book, register or record or an electronic record is kept is itself a relevant fact. So my birth certificate was issued by the Registry of Death and Birth. That was issued by a competent official during discharging his duty as an official, Lordship. That was proved in original before the trial court, but that was not considered. And to that effect, Lordship, I want to submit a citation.
It's okay. When it were birth certificate was procured at on which date? Your birth certificate was procured in which date? Is the date is there? Your birth certificate is procured in which date? Immediately after your birth is there?
Yes, yes, that
When?
was produced before the trial court.
No, no, no. In which date? Date of issue, date of issue.
In the judgment lordship, that is not.
No, no, date of issue. I'm just
Yes,
asking date
yes,
of
yes.
issue. Which was the date of
But
issue?
but fact is that that was issued by a competent authority.
No, which date it was issued? Just tell us which date it was issued. After filing of the title suit?
Prior
Whether
to
it was
that,
issued-
no, prior to that, lordship.
Prior to that, how many prior? 1 month, 2 months, 3 months, or 6 months prior?
PW1.
You have not annexed the birth certificate here? Your exhibits you have not annexed here?
No, lordship.
Why you have not annexed? How can?
Document also is not available with us, lordship, copy of the same. But my humble submission is that that was
See,
issued
there
by
are
a.
3 points. Now, one question is that your Kabinnama.
Yeah.
Now, see, Kabinnama is your mother, marriage between your mother and father.
Yes.
So, that is court is rightly observed that it is not the original, it's a copy. When you produce a
But
copy,
I am on substantial question of law, lordship.
yes,
So that is a birth certificate issued by a competent
that's what
official.
I'm asking. Where
And
is the
to that
date of
effect-
issue? Doubt cast on that. Where's
But
the
that
date of
was not
issue?
discussed. But contention of the learned
Now,
High Court as
your
well as
certificate is there. Now, what is the Kabinnama?
I am on
Kabinnama is not the
I am
original
on-
one.
I am
It's
on
a copy.
I am on exhibit 1, lordship.
No, you cannot be based on your case enter on exclusivity when there is no marriage at all between your mother and father. Suppose.
But when
Suppose I'm saying,
exhibit,
then
but
how can you
but-
exclusively
but
base
exhibit
your case on birth
but in
certificate?
exhibit 1, Abdul Motin was shown as my father.
You just edit through an additional affidavit, you file your this exhibits before this court, will hear to matters. And any other substantial question of law, if you think fit, then you can also punish. Because there's a
Yes, sir.
reasonable doubt also arises in regards to validity or the genuineness of your birth certificate. If it is procured or if it is obtained after or
After
prior to
filing.
the, yes, prior to your filing your for your thing. Because you are how many years
Yes.
old now? You're more than
But
18
that-
years? You are how many? You are
Yes,
the
yes, yes.
age
At the
is
time
more
of
than
at the
18
time
years.
of I was at the time
Then
of
if
filing the
you
suit, I
get
was
your
18.
certificate
I was
nearly
18.
6 months prior, then it's okay. How can you be? Anyway, we're just giving you, we're listing it without mentioning anything. We'll hear the matter on the same hearing on order 41. You just through an additional affidavit, you
Yes,
just
sir. I'll
submit
bring the
the
exhibit 1,
exhibits,
copy of
the
exhibit 1.
certificate copy of the exhibits, you just bring
Yes.
it. And if you think any other substantial question of that, because this substantial question of law, I don't know, it may be sufficient, may not be also. Please just take of it. Well, fixing it, how many weeks you need in that case?
After 1 month, I have to
After
1 month. I have to contact the client.
then after 4 weeks,
Yes.
after 4 weeks, we are not fixing any date. Or let it be after 3 weeks, it will come.
Yes.
List after considering this submission with pursuance to this demand. We're not passing any order.
Yes. A matter may be kept as part head, lords.
No. If it is qualified, my next bench may be at Arunachal. It will be create another problem to you also. In the month of March also, I'll be there. সেইটোৰ ৰখি আছিলে কিবা কৈছিল ন? কি কৈছিলে পাহৰি No, in the morning hours, it was mentioned by
It's not adjournment, your lordship. That was not.
saying that
My lord,
otherwise you are for the
I'm appearing for the
petitioner.
petitioners. Lord.
petitioner.
My lord,
And,
appearing for the applicant, we
Huh.
filed an implement application, my lord. And
Oh,
along
it is
with
an
that,
improvement application.
yes, my lord, because initially we were not made parties in the main CRP.
Acha.
So we filed an application seeking implement, my lord. Notice has been issued on that. And secondly, there's another IA, my lord, seeking for stay of EOGM, my lord. So that, my lord, was allowed, and the interim is continuing, my lord. In that, there are two IAs, my lord. But my friend is yet to file an objection, my lord, in those IAs.
Lordship may kindly grant us some time to file our objection on the I.
In regards to implement, have you already been implemented here? or
No,
not
my
yet?
lord, no.
Notice was issued.
Yes, ma'am.
Lordship will take fresh steps on the respondent.
So you want to implement yourself as a 2 and 3, or? No.
No, my lord.
No.
There are two applicants, my lord, Samir and Sudhir.
For implement application is IA, which was IA? IA for implement is?
2383. 2383.
2383.
So in that case, you are seeking time for filing of.
Yes, sir. Right.
No, I'm asking you, you want to implement, you as a respondent number?
My lord, there are two respondents. my lord.
Four
respondents.
Already
Five
four
and six,
respondents.
yes, my lord.
Okay.
5 and 6. There are two applicants, my lord.
So how many of you who want you to implement as a party? Two.
Two.
That means 5 and 6.
Yes, ma'am.
Okay, then IA 2383. It took Hard MS Anupadhyay, the Learned Council for the applicant, and also Hard MS.
A.M. DeCosta.
AM
DeCosta.
DeCosta. AM DeCosta, the Learned Council for the respondent, petitioner of MS DeCosta accordingly submitted that she needs, how many weeks you need here?
Lordship, 4 weeks stay.
4 weeks.
As your lordship pleases.
3 weeks will
Lordship, because
At least-
service is awaited in the CRP. We'll take
we
fresh
come
steps.
to it. This 3 weeks time to file the application. Considering this, to which MS Upadhyay, the Learned Council for the applicant based no objection. Matter may accordingly be listed after 3 weeks, enabling the respondent petitioner to file her written petition. Next up. And what is IA 2381 is still, you are not still implemented, na?
No, my lord. They have
Uh,
not been impleted, but along with the implement, my lord, we filed an application seeking stay, my lord, of an EOGM which was to be convened, my lord. So the Honorable Court, after hearing us, allowed the stay prayer, and that interim in that application, my lord, is continuing till date. The meeting was stayed, my lord.
Meeting was already stayed.
Yes, ma'am.
No, just I'm asking under 2381, your prayer was for stay of UAGM. EOGM, that's meeting.
Yes.
Now it has been stayed.
It has been stayed. My lord, that
Which order?
the EOGM has been stayed, my lord. That application has been allowed, but in that, I also, I believe, no objection has been filed.
No.
No objection.
No, just tell us, I'm on IA Civil 2381. What is it? 2381.
I know there are
2381 is not that. Pele. That is 2381 name.
My lord, 2383, by then order dated 12th of August 2022, my lord. If my lord peruses the order dated 12/8/2022 in IA 2383, my lord.
Yes.
In that particular order, my lord, a notice was issued, and it is hereby directed that the meeting that is proposed to be held tomorrow, that is on 13/8/2022, shall not be held as proposed until further orders.
That's what I'm saying. Here, this is the, you have saying, implement is actually 2381.
2381.
That's why there's some ask, really, where is the order in fact? Anyway, that has been stayed.
Yes.
So without even implementing you yourself as a respondent,
My lord.
you have prayed for staying of that case.
Because, my lord, this is an offshoot of a proceeding which is pending before NCLT. In NCLT, we are a party, my lord. So that is how, my lord, the order was passed.
So in that case, আপনার হচ্ছে উল্টা হল যেটু 2381 আছে তাতে আপনি 3 weeks টাইম দিও সিকিং আর যেটু 2383 আছে 2383 আছে but it has already been disposed of, I think, in that case. State on under disposed of.
Because they initially they had sought for some time to file their objection in the matter. So accordingly, my lord, stay was granted, but I don't know.
Interim.
Acha, how many respondents are yet to be appear here in this case in CRP or original CRP? Four.
Four, your lord.
All are awaited. All
Yes.
respondents are still awaited.
Notice is awaited, your lord,
Yes, still awaited.
according to the office note.
Tape MS Pathan, she is not here in the party till now. Kali heard MS Swenson, still Anil Council for petition. From the office note dated 20/01/2026, it is seen that neither the AD card nor the unserved notices received by the section. They want to await the service till next day? Want to await?
Yes, sir. Lordship will take fresh steps upon this.
It is the notice of 20/01/2026. It can be awaited till next 3 days. 3 weeks.
Okay.
The matter be listed accordingly to 3 weeks awaiting the service. So your stay is, should I pass any order? Stay it was 2383. That is the order. The interim shall continue till next. Your interim stay will be operating.
Lordship, interim may be continued.
Your stay in at IA 2383
my
will be operating till next day.
My lord.
And in 2381, you file your objection regarding their interim.
Yes, sir, Lordship.
CRP.
Yeah, Lordship, CRP IO, we have an interim order that may be continued.
In CRP IO,
Yes.
CRP IO also, no, CRP IO also.
The NCLT proceedings have been stayed by that order. In the CRP, the NCLT proceedings has been stayed.
Oh,
Yes,
because
sir.
otherwise, anyway, your desk stay will also be there, interim. So all the matters we're listing it after 3 weeks. File your objection because in the last date also you paid
Yes.
for an objection.
Lordship, date may be.
You want any fixed date here after 3 weeks?
Continuing is.
It's already month in your annual budget. 24th of this month.
This month?
Yeah, February this month.
Much obliged.
Grateful.
24th. None of some point. Petitioner as well as respondent is different.
May it please your lordship. My lord, this eyes of for condonation of delay, lordship. Today morning, lordship, one of the applicant informed us that the applicant number 2 also died in delay condonation petition. So we asked them to provide the details of, because we have to substitute the applicant number 2. Lordship, so far as the office note dated 4/6/25 is concerned, Lordship, the service on respondent number 4 is awaiting, Lordship. Office note dated
Yes,
4/6/25.
but now you are saying that respondent number 2 also died.
No, not respondent, Lordship, applicant. In
Sorry,
I,
applicant 2 died.
applicant 2. Applicant 1 also earlier died and he was substituted. But today in morning, we are informed that the applicant number 2 also died. And so far as respondent number 4 is concerned,
Service is still awaited.
service is still awaited so far as the usual court process is concerned. So far as registered post, it says that no such person return to sender. Here, the respondent number 4, he is the daughter of the respondent number 1 and sibling of respondent number 2 and 3. 1, 2, 3 has appeared before this court, represented by my learned friend.
We have appeared, we have filed objection.
They have filed objection, but
So, okay,
So-
do you have any instructions in that regard
So,
regarding the?
4 and 5, Milord, I have no instruction to.
no, they don't have an instruction, but service is not complete, so as respondent number 4. Since respondent number 3 is the daughter of respondent number 1 and the sister of respondent number 2 and 3, if they can provide the correct address of respondent number 4, then we can take steps.
I can take that.
And what about 5?
5 is already, service is complete
On 5.
on
So
5.
remaining only 4, no?
Only 4. So far as office note is concerned, but new development is that the applicant number 2 also expired. So we have to file the substitution petition so far as applicant number 2 is concerned. And if my learned friend provides us the correct address, then we can take steps in between you.
I will take instruction.
Mr. Here, Sharma.
J. Dekar.
J. Dekar. Mr. J. Dekar, Kilani, counsel for the applicant petitioner. And Mr. A. For the, otherwise you are representing
1, 2 and 3.
1, 2 and 3. 1, 2 and 3. Office note. So office note reveals that the service is still awaited for the respondent number 4. However, it is submitted by Mr. Dekar that as the respondent number 3 is the sister of respondent number 4 and daughter of respondent number 1, comma, the respondent number 1, 2, and 3 may be directed, may be asked to provide the present and proper address of the respondent. In that context, Mr. Ganguly submitted that he may take instruction to that. Next, but according is submitted by Mr. Dekar that during dependency of the present application, he is informed that the respondent number, sorry, the applicant number 2 is also died, and accordingly he submitted that he needs some more time to file the petition for substitution of the legal heirs of the applicant. Prior to that, the petitioner the applicant may take necessary steps in filing the interlocutory application for substitution of legal heirs of the respondent. Applicant. List the matter accordingly. After 4 weeks, we will list it.
Obliged.
26.
Hey. Number 26, yes.
Here, my lord, the sole respondent has already entered appearance, my lord. Perhaps they do not intend to file any objection, my lord, or affidavit in opposition. Under that circumstance, lordship may be pleased to keep this matter for final hearing on a short date. Matter pertains to, my lord, whereby the learned trial court below has debarred the petitioners from filing their written statement as well as the written objection, on account of the fact that, my lord, the statutory period of 90 days was already over. So under that circumstances, we are left with no remedy but to file this application before this honorable court. So lordship may be pleased.
So you are not going to file any written objection?
We are not. Lordship may be
Verbal
pleased.
submission will be.
His submission may be recorded, my lordship may be pleased to fix a date, my lord, for final disposal. My.
Or it can be listed in admission hearing column. In that case, it may reach also. Sometimes it happens in the final hearing, it may not reach also. That's why I'm just saying.
My lord,
Let it be on admission column.
my lord, then if lordship makes some observation that on the next date, my lord, then this honorable court would make an attempt, my lord, endeavor to dispose of the. I'm so obliged.
Part Mr. You Mr. R. Borpujai, the learned counsel, the petition. Also part
GJ Soikia.
GJ Saikya, the learned counsel, appearing for the respondent. Services already completed. The record we have, na? Record. The record has
Records have been
already been received. It is also submitted to Mr. Saikya. They are not being written of case. Let the matter be accordingly listed in the admission column. The 2-3 weeks will do, or you want any fixed date here? Fixed date will go in the month of March because we don't have any dates. After 2 weeks, it can be accommodated in either these two courts.
I'd be satisfied if lordship fixes a fixed date, my lord. Maybe in the month of March, my lord.
11th of March.
11th of March.
Let the matter be listed 11th of March, when and the way shall be made to dispose of him.
I'm so obliged.
27.
I read available till 9. No one is, none has appeared on call for the petitioner. List the matter accordingly after 3 weeks as an edit.
58.
My lord, in this case, my lord, subject title should already been disposed of. My we have also instruction from our not to place this matter.
Pardon, I'm not following.
Subject title should already been disposed of, my lord.
Title should already been disposed.
Disposed. Title should already been disposed of.
It has already become infraction.
Infraction.
And what was the IA for?
I was violation of injunction, my lord.
But
injunction order. And injunction petition already been disposed of. All the suit are disposed of. Disposable.
suit is entire suit is
Yes, ma'am. Between them and amicable settlement.
what? Wait. You are Mr.
Yes, sir, ma'am.
Card Mr. S. Sharma, the learning counsel for the petition. And also card Mr. You are Mr.
K.M. Hassan.
K.M. Hassan, the learned for the respondents. It is submitted by counsel for both the parties that the injunction petition as well as the original suit has already been disposed of. Hence, the entire matter has become infractions. And accordingly, it may be expect considering the submission made by and counsel for both sides as the matter has already become the present application of the petition is hereby disposed of as rendered.
Obligation. Obligation.
Details. I
29.
Yes.
I am for respondent number 1.
Respondent number 1.
1. As per office note dated 11/11/2025.
In
The
where, in
petitioner is
IA or
required to take
RSA?
steps- RSA. RSA.
Acha.
The petitioner is required to take press steps on respondent number 3 and 5.
3 and 5.
3 and 5. And a substitution petition
were also to be filed for respondent number 2 and 5, but they didn't file, Lordship.
And you are representing respondent number?
1.
1.
1. And along with the RSA, there is another IA also, 1608. It is for grant of temporary injunction. They are required to file objection, Lordship.
Oh, it was filed by you.
Yes.
So they are not appearing today. None appears on call for the appellate. RMS Arshaka, the learned counsel appearing for the respondent number 1. And she has pointed out that the party office note it is seen that they have not taken steps as per from her submission as well as from the office note dated 11/11/2025. It is seen that the appellant has not taken steps for the respondent number 3 and 5, and also not taken any steps for filing the application for respondent number deceased respondent number 2 and 5. Appellant is accordingly directed to do the needful that estimate accordingly after 3 weeks. And IA was filed by them. Huh? In IA, they sought time for filing their objection.
Objection, but yet now they didn't.
And RMS Arshaka, the learned appearing for the applicant respondent. None appears on call for the respondent. Nor any written objection has been filed by the respondent. The matter accordingly listed along with RSA 20/2024. After 3 weeks.
Lordship, a date may be fixed.
It may not be fixed after 3 weeks.
May I please your lordship, my learned friend appeared for school number 1. On one occasion, he prayed time to file the necessary petition. That is on 18/6/2025. Subsequently, 13/8 was listed. We also prayed time to file legal substitution for the legal years for school number 1. We have not received any information from the other side. My learned friend is represented in respect of plaintiff side, lordship. Ask
My
him to
lord-
provide the names.
My lords, I'm appearing for respondent number 4. There is no counsel for respondent number 1, 2, and 3 yet. And possibly as per last order,
And they are the
respondent number
plaintiff.
1 ought to have been substituted because we have informed that he is deceased.
Respondent number 1.
1. But I'm not appearing for respondent number 1.
But
We-
as per information, he expired about 2 years ago with the code below. Whether they substituted or not, that information we have not received. So my learned friend also appearing in respect to plaintiff side. They are plaintiffs. I am the respondent. My evidence has been closed. That's why we challenge. And the 3 weeks time may be given or 2 weeks time may be also. And then my learned friend will also try to obtain the name for the legal years. Whether they were substituted. or not.
Is there any scope for you?
There is no scope for me providing the names. My lord, because I'm appearing for
He is
respondent
saying
number
that
4.
you were also the plaintiff
Yes,
in
plaintiff.
the original suit.
Yes.
Yes.
You may have some.
I have to seek instructions from the council appearing in Qatar.
That's what I'm saying, that you can seek instructions from your client as well as the counsel for the respondent number 1 also.
I have to
Because
seek
they may not be in a position to collect the name and addresses of the respondent number 2 who died.
Yes, Your Honor.
So till now you have not filed any application.
Lordship, so because of not received legal years of name, Lord.
And what about the you are for 4 only, na?
4. Respondent number 4.
And 1, 2, and 3 they have already appeared.
No.
1, 2, and 3 have not appeared.
1 expired, 2, 3 not appeared.
2, 3 not appears, mean 2 also expired.
2
Also expired.
report has come expired.
No, I don't know. You are saying
No, 1 expired as per report of my learned friend, Lordship.
1 expired.
1 expired.
2 is still alive.
Still alive. My learned friend informed us 1 expired.
1 expired.
Lordship will
3 to year 9.
clear in order dated 18/6/2025 of this code, Lordship. 18/6/2025.
In 6.
there's another
So
order.
it is you who gave the information in.
We have passed on the information, but
Huh?
we do not know the names of legal heirs. I have to seek instructions regarding the name. Moreover, I'm only appearing for respondent number 4. So they have to put on the endeavor to collect the names.
You are Mr.
I'm D. Mazumdar appearing for respondent number 4.
E. Majumdar, 4. Service is still awaited for the respondent number 2 and 3. And from the order passed by this court as well as from the previous note, it is seen that the respondent number 1 died during the pendency of the case. However, it is submitted by Mr. Borgia that they could not collect the legal heirs of the respondent number 1 to be substituted. In that regard, Mr. Majumdar submitted that he may take instructions from his client. Next, let the service be awaited for the respondent number 2 and 3, and the petitioner is hereby directed to collect the name and addresses of the legal heirs of the respondent number 1 to be substituted, and will file a subsequent petition. However, it is also asked the respondent number 4 to provide the name and addresses of the legal heirs of the respondent number 1, if any available source, if from their available sources. List how many weeks you need in that case?
3 weeks.
3 weeks. The matter accordingly up to 3 weeks as an edit to.
Much obliged.
Try to
We'll try
provide
to find the names.
try to provide, because you are the same from the same, and you are the person who gave the instruction regarding his debt.
So we just passed on the information, but we'll try to collect.
Pass on the information, just you try to collect. That's what I'm saying.
Much
Try
obliged.
to
Obliged.
we talk about your number 40. 40.
I'll give you soft copy for now.
Was the request for upgradation because he is leaving. You're leaving.
Submitted already.
He's leaving today, sir. So that's what is upgradation prayer. Anyway, what is the case? In fact,
Lordship, it's an RFA where we have there is a delay of about 90 days.
how many days?
90 days.
90.
Yes. So, Your Lordship, on the last date of hearing, the learned counsel for the respondent had pointed out some irregularities in the application. So, the predecessor bench had directed me to file an affidavit, which has been filed, Your Lordship,
You already
explaining the condonation of delay.
Okay.
Yes, Your Lordship.
Now, yes, what do you want to submit? Do you have any objection in the condoning the delay of 90 days?
Your Lordship, regarding the first application, Your Lordship, there is no explanation.
Delay was not explained.
Not properly explained.
Not
First-
properly explained.
First, the application file along with this appeal, Your Lordship. But later on, they file.
We filed an affidavit, Your Lordship.
Your Lordship, first application,
This is the affidavit which we have. The report of the.
No, where is the order? Where from it was order was passed that he is to file an additional affidavit? Which order?
Lordship, we
Order
were
dated?
informed, learned counsel was also, for the respondent was also there.
My court directed you verbally. I mean,
Yes, yes, Your Lordship.
Acha. Because I am not finding any order on that regard.
in fact, Your Lordship, the condonation application may be taken first condonation application.
Yes, you have to take first the
Then Your Lordship, para 4
para 4 of which?
of condonation application.
Condonation application. Now, additional one or earlier one?
Earlier one,
Earlier.
one.
Para 4. Yes.
Your Lordship, the fact it will be accepted in the interest of justice that the Honorable Court may graciously be pleased to allow the present stay application. A stay and effect the operation, Your Lordship.
Yes, Your
This is the
Lordship. So that is the irregularity which was pointed out before the learned predecessor court, and the predecessor court directed me to file an affidavit where I explain the proper delay. Because of this irregularity, I was told to file an affidavit explaining the delay. Affidavit is on record. Lordship, you filed the
copy.
Your Lordship,
Copy of the affidavit?
it is not with me now, but you also let him submit, Your Lordship. Okay, Your Lordship.
So, are you going to file any written or we can?
No, Your Lordship. That you, in the condonation,
Okay.
I will submit verbally.
So, in the additional affidavit, now you have brought the reasons for delay? Is there
Yes,
any explanation?
yes, Your Lordship. The reasons have been explained, Your Lordship. Lordship, on what had happened was the decree was dated 4/10/2024.
4/10?
2024. After which, Your Lordship, the court had closed for vacations. So I could not apply. Later on, Your Lordship, I had applied on 11/11/2024, and it was delivered to me on 7/12/2024. But Your Lordship, the entire trial court record was not there. So again, I had to come, and then I applied. I applied on 17/12/2024, and I got the entire trial court record on 19/12/2024. Thereafter, Your Lordship, we filed the RFA on 5/4/2025. The delay was because, Your Lordship, we are counsels from Delhi, and even the respondent is based in Delhi, Your Lordship. So, which is why, Your Lordship, there were certain logistical issues which for which there was a delay.
So, as a whole, now it is counted as 90 days.
Yes, Your Lordship.
So, in which para in the additional affidavit you have explained those delays?
Lordship, the paras in the additional affidavit, I have Lordship 1 to 5. Para 1 to para 5.
It was a money suit.
Title
Manisha.
suit, Your Lordship.
Huh? Title.
Titles, yes, title suit.
It was title suit, Your Lordship.
Anyway, the judgment was delivered on which date you have said?
4/10/2024, Your Lordship.
This is the date of delivery.
Yes, Your Lordship. You'll file on 5/4/2025.
Registry had calculated this
Your Worship,
calculation.
90 days, Your Worship, it is
Because
Yes, Mr. Chair.
Your Lordships. Your Lordships, in this case, Your Lordships, the facts he has stated in first application, Lordships, regarding the applying for certified copy of the judgment degree and the records, there is nothing on record, Your Lordships. Because they have not annexed anything with the this convention application. So how can
But here they are in the main case where it is annexed.
Your Lordship, this is not with me, but still, Your Lordship, it may be verified if the facts are stated is correct or not. So this is one part, Your Lordship. It ought to have been with the convention application. So this is one object, Your Lordship. Second, Your Lordship,
Have you annexed all this? The date on which you have received the certified copy, date of application, there will be there in the certified copy itself.
yes, Your Lordship. I'm taking Lordship to that. Lordship, Annexure 1, which is at page 28 of the suit, I mean the RFA, that shows that I have received it on 19/12.
No, that is true. You have submitted it. Subsequently, you file another.
Yes, Your
certificate.
Lordship. And as far as my first application, which I had applied on 11th of November, which I received on 7/12, that Your Lordship has been filed along with the affidavit. The first page has been filed along with the affidavit.
Affidavit?
Yes, Your Lordship. It is at page 13 of the additional affidavit which I have filed now.
No. Judgment you applied when you got. Your Honor, the judgment he applied on 17/12/24 and got the same on 19/12/24.
Which I accept. Prior to that, on 11th November, I had filed for the certified copies, but I did not get the entire trial court record. That is why I again subsequently came and filed on 17th, which I got on 19th.
No. Just now you have submitted that on 11th of November. You have applied for the certified copy.
Yes, Your Lordship. But I
And
did not
the
get the
delivery is at
entire
7/12.
Yes,
yes. And the entire record was not there.
No,
Delivery
no,
is
Your
at 7/12.
Yes, Your Lordship.
Is there anything is there? That
Lordship,
you
I have-
part on 7/12.
Yes, Your Lordship. If Lordship has the additional affidavit which I have filed.
No. Documents.
So it is
17/12/24, he applied for the judgment and he got on 19/12/24.
so that is as per his submission. That is the later part. I mean the part which has not been received by him earlier.
Your
That
Lordship.
is his submission.
But Your Lordship, fact remains there. On 17/12/24, he applied for the judgment and degree, and on 17/12/24, he's also applied for the plant and all other documents, Your Lordship. So the
For the copy of the judgment on 17/12 only.
17/12, Your Lordship, 24.
Lordship, prior to 17/12/24, I had applied on 11/11/24.
Is there anything there?
Lordship, in the additional affidavit which I have filed.
Affidavit you have not. These are not here in additional. In which
Lordship,
page?
page 13 of additional affidavit.
Yes. নহয় না জাজমেন্টৰ কপি ক'ত এপ্লাই এফিডেভিট কি এইটো কি এডিশ্যন part of the records which we have not received, we had applied for on 17/12, that is okay, and 19/12 we have received. That is there.
Yes, your lordship.
I was asking you, where is the order, where is the certified copy you have received on 7/12 on your application in 11/11? Is there?
Right, your lordship, but I have, that is what I'm acknowledgement. The first page I have attached. Page 13, I have attached.
You receive a record.
It's not here. Hold a second.
Your lordship, the submission is that he applied for the certified copy of the judgment on 7/12/24.
No. He is saying that he applied for the judgment on 11/11.
11/11/24, but nothing is there, your lordship. It is on 17/12. Both judgment as well as your lordship, the other trial court records, plaint, all these. He applied on 17/12, your lordship. So total, your lordship, nothing is there.
Can you get me that?
Because even if condemnation, your lordship, 90 days, he has to explain properly. In the
Here-
casual
here
manner,
he has-
the way it was drafted and your lordship, before your lordship, upon this, your lordship, this condemnation application cannot be allowed.
No, here it is 11/11 is here.
That's why I'm,
11/11 is here.
yes, your lordship, I had filed.
It will give. It's hard. See, the initial part, you see 11/11. There, yes.
Your lordship, this is 11/11 is the first order of the trial court. First order. This is no way connected with the judgment and decree.
No way connected.
Your lordship, it is the first order. The registry of the title suit, of money suit, with deficit court fee is so and so. It is a start of the trial, your lordship. When the court suit was presented, there was a deficit court fee, which I have to pay.
Oh, these are the order sheets.
This is the orders. It is no way connected.
Judgment, copy of judgment.
Copy
where
of judgment is there, your lordship. I have filed fragmas. It is 17/12.
Then how-
Lordship, I was given 72 pages of the documents, but the entire trial court record was not received. So there was,
copy of judgment when you have applied for. Later on, you have come to know that we need the entire document, entire record. Maybe your for requirement. And the question is that when you have applied for your judgment, the copy of the judgment.
Lordship, on
It is the 11/11, that is it for the entire record.
No, only for one order, your lordship, deficit court fee.
Oh, deficit.
no,
First order.
Lordship, I had applied for the entire trial court record, but that was through someone here. So maybe there was a miscommunication, but I received only 72 pages of document. I did not get the entire record. That is why I personally came and I applied and then I got. That is why. But lordship, this is all bona fide. Otherwise, I wouldn't have shown this. I had applied through someone.
There is one 11/11 is there.
11/11, yes, it is the first order, your lordship. How can that be counted, your lordship? It is the first order. Even it is not, there is no start of the trial, even the suit is not started because it was the deficit court fee. So after the conclusion of trial, it will be the judgment and decree first. And thereafter, narration is that thereafter, when he found that there is no trial court records, then he applied for that.
Yes.
What is applied? He applied for the plaint, your lordship, there is 17/12. On the same day, he applied for the judgment and decree. On the same day, he applied for the plaint, your lordship, and other documents. So the statement which he made, that he applied 11/24 for a whole document is a false statement, your lordship.
Lordship, this is
How
not,
can it be the true
it is not false. I have received 72 pages, which was sent by me through, the soft copy was sent. When I realized the entire document is not there and I cannot draft the RFA, I personally came and I got.
You have not annexed your certified copy which you have received, huh? You have not annexed it.
Lordship, I have not annexed the first, the one which I had applied on 11/11 is not annexed.
Now see, as per your submission, 11/11, you have applied for the judgment
Yes,
copy
yes, your
and
lordship.
you have received on 7/12.
Right, your
But
lordship.
you have submitted that it was not completed, the whole record.
Yes,
Then
yes.
again, you have applied for on 17/12. It's okay.
9, yes, yes,
Yes,
yes, your
but you have not annexed the copy of the judgment that you have received on. Here it is the first page of the test, that one.
Yes, because your lordship, that was, I only wanted to show that I had applied on 11/11 and received on 7/12.
No, but 11/11 is for the entire record. Even if suppose you have applied for this for the entire record,
Yes, your lordship.
not for the copy of the judgment. Because to file the appeal, the copy of the judgment is sufficient to file an appeal.
Lordship,
Later on, it may be
I'll
the record, entire record, so you may apply.
Lordship, I'll explain why the
Yes,
entire.
Mr. Jha, anything to submit?
Your Lordship, next submission, Your Lordship, regarding even after Your Lordship obtaining the certified copy of the judgment on 17/12/24, the appellant only filed the appeal on 5/4/25. There is no explanation to that. What happened in between that? The explanation that we are residing in the Calcutta or Delhi or the appellant is also residing there. This will not be there. For these 4 months and 5 months. So nothing is there, Your Lord. What happened in between that? Even there is nothing, that is a miscommunication and all. Only explanation is that both are living there, so they have a prerogative to file after 3 months. So this is not explanation.
May I explain, Lordship, why the entire court, the trial court record was important is this is an ex parte decree. So we did not have a single document about the proceedings in front of this court. So in order to file the first appeal, we have not even filed obviously written statements. We had tried to file an impediment, but that was we had tried to file, we had filed applications, but we were not allowed, which is recorded in the last order also. But however, Your Lordship, in order to contest the matter on merits, we required the entire trial court record, without which it was not possible to file the RFA. We did not have a single order. And Your Lordship, moreover, the time it took is because we needed to coordinate. The filing, we have never filed it before this court, so that is why we required some time to. There were logistical issues, Your Lordship, with the council and everyone. There is a particular format which is followed. So in all that, it took time, Your Lordship.
Your Lordship, my humble submission, Your Lordship, this cannot be a ground. For continuing a delay, reasonable ground should be there, Your Lordship. And explanation should be proper. The statement which are made, you are not contradicting the document on record, Your Lordship. A statement is not as per the document, Your Lordship. Explanation which is given is not possible, Your Lordship. So my humble submission, under the circumstances, Your Lordship, even if it is a 90 days, Your Lordship, it cannot be.
Lordship, but all the documents are there in front of Your Lordship, Your Lordship.
Sir.
Yes.
All the documents are in front of Your Lordship. It is a very bona fide submission about what has transpired during since the date of judgment and till the date of filing.
This is the problem, Your Lordship. There is nothing like this. What happened from when he come to know regarding the judgment, that is also not there, Your Lordship. It is
Lordship,
a vital thing.
we came to know there was an arbitration proceeding which was
Where you written in your petition?
Lordship.
No, Your Lordship.
Lordship, that is already in the trial
He has
court.
the knowledge.
Lordship, it was already there in the trial court record, Your Lordship, where we had tried to contest this matter. However, the same was, we were not allowed. The application was dismissed. It is there in the order. After that, Your Lordship, we tried to apply. However, the court had closed for vacations, Your Lordship. Thereafter, we applied on the first day possible through a council over here. We did not get the entire documents, Your Lordship. I came, I applied, I got the documents. After that, Your Lordship, we started.
This is the contradictory statement, Your Lordship. This is not. That's not record, Your Lordship.
Lordship,
11/11, he is not applied for anything, Your Lordship. Only a first order, Your Lordship. This is no, we are connected with the appeal, Your
Lordship. We have got.
He would have been concerned with the judgment and degree, Your Lordship. That was applied on 17/12.
Lordship, we have got the entire bunch of 72 pages, Your Lordship. In the when we filed for on 11/11, the council from here had sent us soft copy of 72 pages. If your lordship permits, I will file that also. The entire 72 pages, but I have soft copy. I don't have a hard copy because when I perused the soft copy, I saw the entire record is not there. So I had to file the, again file for the entire trial court record.
It means your lordship, he got the certificate copy through a soft copy. So you're saying so?
Yes.
Your lordship, there is no provision of such that will get certified copy through the.
Lordship,
soft
the
copy.
council over here must have got the hard copy. I was sent the soft copy. I don't stay here, your lordship.
Time has passed. You also filed affidavit. Why you are not annexed there? Your lord.
Civil. One. You are Mr.
Datta.
Mr. S. Datta, Thane. Taking continuation of delay of 90 days in filing the connected appeal against the judgment and order dated 4/10 passed by learned civil judge senior division number 3 Guwahati in GS number 445 passing the ex parte decree against the present appellant where they were irresponsible. From the record as well as submission from the council for both sides, it is seen that there was some the earlier application was no clarification or explanation in regards to delay, and there was also some error. And in view of this, an additional affidavit was filed by present applicant, whereby the grounds for delay has been filed as well as the earlier applications were filed. It is submitted by Mr. Datta, the learned counsel applicant, that in para, how many paras? 2 to
Lordship 1 to 5.
1 to 5. Already explained the grounds for delay in preferring connected appeal against the impugned judgment. Next, submitted by Mr. that the judgment on order, the ex parte judgment and order was passed on 4/10/2024, and thereafter the petition started. Hence, they could not apply for the certified copy immediately. However, the certified copy of the judgment was applied for on 11/11/2024, and they got the copy on 7/12. But as the case was proceeded ex parte, for preferring an appeal, the entire case record was required, and for which another application was filed on 17/12/2024, seeking the entire case record. And which entire case record, which was received on 19/12. He further submitted that as the council resides in Delhi, as well as the petitioner applicant of the appellant is a resident of Delhi, there was some logistic issues in preparing the appeal, and for which there was a delay of 90 days. 90 days in preparing the appeal. He further submitted that there was no intentional actions or negligence in preparing the appeal with 90 days delay. 90 days delay. Further submitted that as the case proceeded, as the judgment was passed ex parte, the applicant could not confess the case, and if the applicant is not allowed, if the applicant is not given a chance to raise the case, the applicant will be prejudiced, and at the same time, no prejudice will be caused to the respondent side. Mr. Dr. Mr. Dr. is accordingly paid for condoning the delay of this. Next para Mr. Chandler respondent submitted in that initially the application was filed without any proper explanation of delay, and there was also some wrong in the earlier application, but presently the additional affidavit has been filed, but there is also no such proper explanation. Mr. Chah further submitted that though the learned counsel for the appellant is submitted that he applied for the certified copy of the judgment on 11/11/2024, but the annexures filed along with the appeal, it reveals that he had applied for the copy of the judgment only on 17/12/2024, and there is no document to show that no document to show that the copy of the judgment was applied for 11/11/2020. Thus, it submitted that the submission made by the learned counsel for the applicant does not tally with the documents which have been furnished, which have been furnished along with the connected. It further submitted that the annexures filed on 11/11/2024, he received the certified copy of only the initial order of deficit court fee, and there is no other proof. He applied for the certified copy of the judgment on 11/11. Mr. Chai accordingly raised submitted that though there is no though there is a delay of only 90 days, but due to unexplained delay by the present petition is liable to be dismissed. Next, hearing this submission made by learning the annexures along from the annexures file along the appeal, is seen that the certified copy was applied for on 17/12/2020, by which the certified copy of the judgment was also received by the learned counsel for the received by the applicant. However, from the annexures filed along with the additional affidavit, it reveals that the certified copy was applied for on 11/11/2020, and the same was received on 7/12/2024. 24, but the copy which is received is only the first of the initial order passed by the learned court bill. But it is cannot be denied that the certified copy of the said the certified copy was applied for on 11/11/2022. There is no proper document to that regard. in to held that the certified copy of the judgment was received on 7/12/2024 and the entire case record of the document was received on 19/12. Next one, we're considering the entire circumstances of this case and also for the period of delay as well as for the ends of justice. This court is of opinion the delay of 90 days can be concluded in preferring connected against the judgment and order dated so and so. In view of this, the present petition is allowed. Delay of 90 days has been condoned. Registry is hereby directed to register and the number be connected. Present. Okay, your delay has been condoned.
Right. Your receipt date may be fixed for appeal listing of that.
No. Register, it's not been registered yet.
Yeah, no.
Number 16. So I am appealing for the sole respondent.
So it was time being, yes? What is?
We have filed the affidavit. The LCR may be recorded. Is not all. Amendment
You
application.
want to submit anything?
No.
No, it was time being, that time. That's why.
Yes.
Otherwise, you have filed your affidavit.
Affidavit.
So it can be listed for final hearing or what?
Lordship, in the meantime, LCR may be called.
Achha. For LCR, we have not received the LCR.
LCR, two cases that's been.
It will be required. I think. You are Mr.
A. Muhammad.
A. Mohammed. Pardon, Mr. A. Mohammed. The learned counsel for the petition. Pardon, Mr. Doctor. Doctor, the learned counsel for the respondent, and it is submitted by Mr. Doctor. They have already filed their affidavit in opposition. Post call for the DCR, and that matter may be accordingly listed for final hearing on receipt of the LCR. From where it has to come?
It's from Morigaon.
From Morigaon. We're not fixing any days. Immediately after receipt of it can be.
Lordship, two case record. Another is there. Title suit number 12 of 2009.
Justice. One is.
Lordship. Wait, 20. Title suit 20. New to 53, 20. 53, 21. Title suit 53, 21. 3 of 21.
No, one is title suit number 50.
3 of 2021.
53 of 2021 and another
21 of 2009.
Another is TS 21 of
2019.
revision or record. The TCR of both is record BP or rest will be list the matters after 3 weeks or on receipt of the LCR. On receipt of the LCR, it will be immediately listed. Will be immediately listed.
Like.
Hey, there is no sheet. I'm appearing for respondent one.
We are paying for
Respondent one.
one. This I is what?
My lord. On highway, my lord. Was disposed of, my lord.
It is already disposed of.
3654 was disposed of, my lord. 3654, my lord. Public 24, my lord. And this honorable High Court was pleased to
Was
stay
disposed
the
of.
execution proceeding, my lord.
What do you say? It is disposed of.
Disposal. 3654, my lord.
3654. Yes, 3654.
Yes, my lord. Stay in the execution proceeding, my lord. Lord, in this,
So
my lord,
this was for stay of the execution only.
execution room.
It has already been stayed.
Statement. Fight order dated, my lord.
1912. I'm sorry, 912.
1912, my lord.
No, not 1912. 912.
912. 912 2024.
Then it is disposed of.
Yes,
Stay is already there.
Stay. My lord, in
This
this,
the stay is already there, but it is not
There is another IA, my lord, IA 3159.
3-1.
This one is also for stay, man.
Then yes, Mr. Islam then.
my lord,
It was
already state the execution proceeding, my lord.
But whether service is completed or not regarding the other respondents. The service is completed, then my lord, then it will go for hearing. Or if service is not completed, my lord, they will have to take place.
No, by the 3654, your execution is already been stayed. So now why this one?
But I am on behalf of appellant defendant, my lord. I'm not
Whatever, you are
plaintiff.
for appellant defendant, I can
Yes,
understand.
my lord. The plaintiff file
Execution
execution, my lord.
that has already been stayed by your IA 3654.
Yes, my lord.
Then why this one? This IA is why?
My lord, this IA was filed before this IA, my lord. IA number 3654, my lord. The
Yes.
subsequent, there was a development, my lord. The code below, my lord, that is the execution code, my lord, issued a
Now you
notice, my lord.
submitted 3159 was filed earlier for stay,
Yes, my lord.
and in spite of pendency of that application without disposing, you have another application for stay on 3654. Why?
Yes, my
Why?
lord. My lord, further development was that, my lord, the judgment was passed 2000, my lord, 2000, my lord. My lord, the order in execution case, my lord, order was passed within 30 days from the date of passing the judgment and decree passed by the civil
Now,
judge
whatever
junior
your
division.
now your purpose is served now.
Yes, my lord. Purpose is served.
So no need of keeping pending these IAs.
Yes, my lord.
Can be disposed of.
Yes, my lord.
Yes, yes. Okay, then it's not. It already stays there. No? IA 13159 to the IA 3159. Hard Mr. Assistant and petition. Hard. Taken also hard Mr. Estes, but it is. This in that the I was this the present I was filed for bring for stay of the execution proceeding, but দুইটা একলগে লিখবো হ্যাঁ এটা হইছে IA 3654 of 2024 আৰু এটা IA আছে 3159 of during dependency of the IA 3159, another IA was filed on 3654 due to some subsequent development, and from the order dated 9/12/2024 in IA Civil 3654 public 2024, it is seen that the execution the further proceeding of the execution proceeding number no, title execution, sorry, title execution proceeding number 58 of 2022 has already been stayed. Which was filed in connection with judgment and decree dated 22/07/2024 in title appeal number 21/2022 passed by learned civil judge senior division court. As the execution proceeding has already been stated, both the I has already become an it's not it's already become has already become infractors, and accordingly no infractors in view of this both the IS have already been are disposed, not infractors nearly main IRS to the dispose করে দিব। So you are for the one.
Only one.
You are for only. Yes, what your office note says?
No, TCR has not been received, my lord. TCR has not been received, my lord.
Not received. No, TA is not received.
LCR, my lord, that is.
No, LCR of, sorry, TCR of TS 103 has already been received, and TCR of TA 21 is not yet received. Received nahi, আহিলে নেকি? এটা আন এটা appeal to happen. itu আছে মানে ইয়েটো there are 11 numbers of respondents, so he is one. And what about the others? Have you taken steps?
Took steps as per High Court order.
No, as per High Court's order, where? Press steps, huh? You have taken steps on 26/11. Thereafter, what had happened, we don't know. He had already appeared, number 1 had appeared, number 2 to 11. There is no note at all. In their regards to their service, AD return, there's no note at all. Nothing is there. Only regarding the record call for the notes recording call for is. The one note is there, neither the AD card nor the answer notice is received from the these are all 2 to 11 are the pro forma.
Pro forma.
The plaintiff made party, my lord. That is why we also made party in appeal.
You said these are
They
pro
can
forma.
take Dusty also, my lord. They can take Dusty.
Dusty also. The civil matter Dusty can be taken. Try
Because
one because there you have made them party as a pro forma respondent. You have to make party.
Lord, we have taken steps, my lord.
No, these are awaited since 2024. That's what I'm saying. It is awaited till more than 1 year, huh?
We will take fresh steps, my lord.
What is the
Not
problem
Dusty,
with
my
you
lord.
taking Dusty?
Not Dusty, my lord.
No, what is the problem?
My lord, the whether party will cooperate with me or not, I do not know. I'll take register post, my lord.
Register post, no more register
With
post.
AD.
You have to take speed post.
Okay, speed post, my
Speed post.
speed post.
Want to take?
Yes, ma'am.
Because why I'm saying, why Mr. Das is also pointing out, because your service is awaited more than 1 year, already lapsed. So Dusty may help you. But I don't know if you prefer on
Speed post, man.
Huh?
Speed post.
Speed post.
Speed post.
Mr. Assistant of the has done it on the respondent number 1. Stop the office note dated 7/4/2025 reveals that neither the AD card nor the answer notices on the respondent number, pro forma respondent number 2 to 11, is received received by the concerned section. Further, the TCR of TS 103/2024 has already been received. but TCR of TA 21/2022 is not yet received. Issue reminder. Further, considering the submission made by Learned Counsel for the appellate, let fresh notice be issued through speed post and usual process. The pro forma respondent number 2 to 11. These the matters according to the ইয়াতে ও নাই এই দুইটাই নাই টিচাৰ নাই পইলত আনচাৰ নটিচ লিখিলে নাই এইটো কি পইলত আনচাৰ নটিচ ও তাৰমানে আনচাৰ নটিচ ইজ ৰিচিভ বেক ইমান কেজুৱেলি কিয় কাম কৰিছে লিখকচোন অলপ বেয়াকে লিখ অলপলে ক'ত মিলাব হা এইটো মই চাই দিম though as per the office note it is reported that the answer notice and the AD cards is not yet received, but from the record it is seen that the answer notice to the respondent number 2 to 11 has already been received back. And at the same time, it is also seen that the case record of TSO and TSO is also not received. As it is seen that the registry public the consent section has gave the note, office note, without even perusal of the record. Registry is accordingly hereby directed to give the proper note, proper office note, and the reminder may be issued for the TCR. Oh, sorry, it is not the TCR of TC.
That's why, in the process it was not shown.
But
Possibly it was not shown regarding
not shown, not shown. Only from the office note I thought that it is the TCR.
Yes.
So it's not the TCR.
My lord, stay order, my lord, 9/12/2024 may be continued, my lord. Because there is a execution
There will
proceeding.
It was list Nikki.
9/12
Instead of listing.
stay, my lord.
Okay, okay. Then, তাতে দুইটা প্ৰথমতে তাতে ডিসপোজ কৰিছিলে দুইটা ৰেকৰ্ড তাতে লিখিব যে ইন ভিউ অফ অৰ্ডাৰ পাছড অন 9/12/2022 the execution of
Number 3654.
we state till disposal of the connected RS. I do it. That knowledge I dispose to that or at least 4 weeks. Okay.
But in this matter, my lord, service is awaited, my lord, on both the IA and the RSA, my lord.
Why? Proper address
That's
is
a
there.
new case, my lord, 2025 RSA, my lord. So let it come after 4 weeks, my lord.
In one order, the registry was also directed to track the consignment report. Postal receipt, but I disseminate postal guard and postal track. Tracking report, so they have annexed here postal tracking to the second. Have you perused? No, na?
Well,
on the last occasion, that is on
Yes, yes.
1812, they were asked to
Yes.
file the track consignment report. That is accordingly filed. I mean, the annexed by the registry, the postal tracking consignment. It will take some time
Yes.
to investigate record. Okay, the part Mr. Esther, the learned counsel for the appellate. None appears for the respondent. In pursuant to order dated 18/11/2025, the registry has already submitted the track consignment report for the respondent number 1. However, no one has represented the respondents. Let the matter be listed after 3 weeks. We'll list
Well,
after 3 weeks as an edit.
and regarding LCR also, my lord. PCR
Yes, yes,
also.
sales be called
IA, my lord, same order, my lord, interim is there, my lord.
in I.
IA.
I to bring it check consignment report same order for earlier the interim order for stay of execution case number 1/2021 be continued till next day. In IA Civil 327.
File here.
34.
Your Lordship. Lordship, as per office note dated 25/9/25, service has been completed.
Service is completed.
25/9/25, office note.
As a whole, 18 numbers of respondents were there.
Yes, Lordship.
So you are representing who?
My lord, 14 to 18, my lord.
14 to 18.
My lord, 1 to 5 had already appeared.
1 to 5 already entered into appearance, and you are 14 to 18.
Yes.
14 to 18. The others, that is 6, 8, 13, 8 to 13, they are not there.
They are not present.
No, they are 14 to 18 only.
Yes, my lord. The
You are
rest, they
2
have,
to 18.
yes. Rest have not appeared.
Not appeared.
As of yet.
6 to 13.
You are 34. You are Mr.
D. Burwa.
T. Burba. Heard Mr. T. Burba, they done it. And you are Mr. G. Imtiaz. na?
Yes, ma'am.
Imtiaz, General Council, appearing for the respondent number 14 to 18. It appears that the respondent number 1 to 5 had already entered into evidence to his counsel. From the office note dated 25/9/2020, it is seen that the service is completed for all the respondents. However, some of the respondents does not then we listing it on admission column. In view of this, this year we require here. We have not received it this year.
This year required.
Required, na? This year we call for registry will do the need registry matter in the admission column after 3 weeks.
May I please, your lordships? The office note reveals the service upon respondent is complete. My friend
have
is
appeared, Lord. For one and two, both the respondents are having.
2 respondents were
two
there.
respondents.
Then we can
TCR may be required in this case.
TCR will be
Might.
required.
Might.
Then we'll do one thing, we'll call for the TCR and we'll list the matter in
In admission column.
In admission.
in admission. Heard Mr. Talk, the learned counsel for the petitioner. And also heard Mr. S.K. Potter, the learned counsel appearing for the respondent of 1. Services already completed. TCR call for registry will do the need. List the matter after 3 weeks in admission. As an edit. So you are listing it after 3 weeks. You need any 3 weeks as an edit to be fixed by the registry. Let the TCR be called for. In admission column, we are listing.
Might. Interim order will continue.
Interim was dead.
Might. 13
Interim
weeks.
we continue till next day.
Okay.
May I please, your lordship? Well, the respondent already appeared and filed their IA. We have received the copy of IA, but has not been shown in the cause list, my lord.
Who had filed the IA?
I have filed one IA for vacating the stay, Lordship.
Oh, we have not received.
Not
It
yet.
is not there.
Not yet there, Lordship, but without that also, I have this
challenge the maintainability also on that part. Lordship. A short date may kindly be fixed regarding.
3 weeks time may be given. 3 weeks time may be given. In the
A
meantime,
date may kindly be fixed, Lordship. Admission column may after 2 weeks or any date, Lordship.
after
Okay,
3
but
weeks.
you have filed your one
That
vacation
is on
stay.
for vacating of stay.
Acha.
But
That
on
is
admission column on that day, that matter may be disposed of, may be taken up together also.
Okay,
Lordship.
then we call for this.
IA number it
call
has
for the
not
IA
been
first.
numbered, Lordship.
No.
Maybe
You
some
may
defect.
ask the registry to, if there is any, it can
Yes,
be
madam.
tagged with the record.
If there is an IA, then maybe.
It can be tagged with the record and we'll
Yes,
stick
Lordship.
it on admission column.
Uh,
Your
there-
admission,
thereafter admission column.
the issue of maintainability will also be hard.
Yes, madam.
You are Mr.
Ziu Ahmed.
Heard Mr. G.U. Ahmed, learned counsel for the petitioner. Also heard Mr. S.K. Poddar, the learned counsel for the respondents. It is submitted by Mr. Poddar that they have raised the issue of maintainability, as well as they have already filed one IA for vacation of the stay order. But the said IA is not tagged along with the present petition. The registry is hereby directed to tag the interlocutory application filed by the respondent on the next date of listing. If
A
already,
date may kindly be fixed, Lordship.
next date of listing, if already let the matter be accordingly listed in admission column. So we have received here we need the record,
Not required. Lordship,
not
required.
record. List the matter accordingly in admission column. Yes, on which day? 5th of March will do.
Yes.
Is there any interim? No.
Interim is there, madam. Sorry,
Interim was there.
interim is there.
A short date, if Lordship, that is I have.
I have
because a
vacating
decree has been
stay.
stalled here, Lordship.
I have
Without filing any appeal, a decree has been stalled here, Lordship. No appeal has been preferred by them. By filing the CRP, they have challenged the entire proceeding without any impugning any order, Lordship here. Simply they have filed that if we file a limitation appeal, there we have to file a condonation. And for that, court may not pass a stay order. That's why this CRP is there, Lordship.
We are come for
A short date may kindly fixed, Lordship.
against the execution, my lord.
Without preferring any appeal,
Execution,
Lordship. No appeal.
There is some
What is the stage of execution now? It has been stayed.
statement.
Stayed by
You
this
got
order,
the stay
Lordship.
order.
The execution almost done without hearing the
No, whatever. Stay is there.
Yes.
So you have not preferred an appeal.
and there is so many land and so many family is staying by building their house.
Whatever.
No appeal, Lordship.
Everything is there, my lord.
A decree has
It will
been
be hard at the
put
admission
to
column.
You have challenged the decree
Yes.
without preferring any appeal.
Yes.
And that too, you have already obtained the stay order.
As per my knowledge, my lord, already they have filed the appeal with
So let him stay. If then appeal, then stay will be considered by the appellate court. Then why by this CRP? If that is there,
So
41.5
you
is
have the
there.
information that they have already preferred an appeal.
Oh, I have
Appeal is
heard.
already there.
I have
No,
heard.
I have recently filed
This sort of
after stay, after getting stay, they filed the petition in the execution court, and thereafter they filed the appeal with condemnation of delay in the.
That is, it is already become infractual in that.
No, my lord.
So you're saying against the decree, they have preferred an appeal. After getting the stay here in the execution, they have preferred an appeal. The
No,
appeal has been already
without,
preferred
with-
against the decree. So why this
Without,
CRP is
without
pending?
delaying the condemnation and admitting the appeal, the execution will be done, and the party will be hampered. Therefore, we come for CRP, my lord.
How this CRP is maintainable? That's why I raised the issue of maintainability, Lordship.
Before filing the appeal, we come to file the CRP. my lord. That will
So
be
you
hard
don't-
at
you
that
don't
admission
prefer
column.
any condonation. You don't want to prefer any condonation petition. That's why you directly prefer the CRP.
CRP. Against the execution or execution order. my lord. Against the execution case. By explain everything, my lord, without suppressing anything. my lord. There is some technical point that will be hard at the admission column.
Okay, when it
In the meantime,
A
there
short
I
date
will
may kindly be given.
23rd of February.
Oblige you.
Interim paper, why don't we say it? It is which decree?
Ma'am, the lordship. My lord, 37, 38 into both the CRP arising out of same title suit. My learned friend appearing in a 38, my lord, same respondent. My lord.
Also 37.
37. Then my lord, in this
No,
matter,
in 37 also you are appearing.
then my lord, TCR may be called for and fixed for admission.
38 also you are appearing.
TCR may be called and fixed for admission. my lord.
I have filed Ukalot
So
Soma in item
37
number.
also there's a the service is completed.
Yes, but since my learned friend represent.
You represent the respondents.
Lordship.
Yes. Thank you.
37 and 38. I think Mr. P.K. Learned Counsel petition. Mr. R.R. Mujum, the Learned Counsel. Both the CRP number 529 of 2020 and 470 of 2023 for the response. Thus, the service is completed on the response.
Oh, you leave.
Yeah, here you need the TCR.
Yes, my lord, TCR necessary.
Same TCR will do, isn't it?
Then one is sufficient.
We have received TCR. In 470, in fact, we have received the TCR.
Then my lord sufficient. Then
it's okay.
for admission, my lord. For admission, my lord, lordship may fix after 2 weeks.
TCR has already been received. Let the matter be accordingly listed.
After 2 weeks, my lord.
Pardon?
After 2 weeks, my lord, for admission.
Let the matter be accordingly listed for admission hearing.
Yes, my lord.
As an date.
Deeply obliged, my lord. Deeply obliged. Lord, my lord, in this case, my lord, kindly have a look on the last order, my lord. That is on 19/12/2025. Last order, my lord.
Yes. What?
Lordship, in 19/12/25, my lord, considering the urgency of the matter, the Lord Court date fixed on 6th of February. So we have been directed to take the steps on speed post as well as the usual process. We have taken both the steps, my lord. But service record shows that their service is not complete, my lord. And Lord Court date fixed for final argument on 6th of February. 6th of February. So there is the interim stage very urgent, my lord. Otherwise, the last stage of hearing. So I'm praying for my lord today for stay of the proceeding, my lord.
Will the original proceeding is?
My lord, lordship will find that impugn order at.
It's a money suit.
The money suit. Yes. So, my lord, what happened, my lord? In this money suit, my lord, they preferred and that we borrowed some 3 lakhs of rupees, my lord, and there is a hand note, my lord. In the meantime, what happened, my lord? The hand note sufficient. The ink of the plaintiff himself admitted there is a difference of ink. Then we make an application before the court that for expert opinion is necessary to send the records for the forensic. Then, my lord, court has allowed our prayer and directed us to take a step. What happens here, my lord? The counsel we have engaged in this matter, he has not checked that order. Since he failed to take the steps, accordingly, the trial court below has not considered that period. Then now we are before this court. Our whole case is based on in the hand note whether this is my signature or not. This my case whole based on this is the issue. If the court has found their earlier order passed in our favor, yes, there's a reasonable ground we have taken. Yes, expert opinion is necessary. Lordship, kindly have a look. My lord, 6th of February is date fixed for argument, my lord. If no interference from this court, then nothing remains of the scheme matter. So kindly, my lord. Page 25, Annexure 3, my lord. And defendant, my lord. This is an application I made calling for the expert opinion to determine the age of the ink used in signature, my lord. Then, my lord, lordship will find our prayer has been allowed by the trial court. Annexure 4, page 27, that is on 23rd May 2025. Lordship permission, I am going to read this order, my lord. Both the parties are represented by the learned engaged counsel. Today is fixed for order on petition so which is filed by the defendant under section 151 of CPC. I have already heard both the sides on the petition. Petitioner submits that the petition that the determination of the age of the ink of the signature of the defendant and of the ink used in the hand note, that is in the contents of the signature of the scribe, are very much essential to the suit because the defendant from the very beginning is taking the plea that the said hand note is forged and it was not executed by him for taking any loan from the plaintiff. The suit has passed all the stages and now is at the stage of argument. They have already prayed for expert report and same is there in the records. But due to transfer of the case from the Court of the Civil Judge Senior Division to this court and the pandemic situation, they could not make any prayer for determination of the age of the ink earlier. And the suit proceeded with the evidence of both the parties and accordingly concluded. It is submitted that the determination of the age of the ink used in the said hand note is very much essential. And if the same is not allowed, defendant will be deprived of his proper defense. It is also submitted the plaintiff admitted in his evidence about the difference of color of the ink in the signature of the defendant and in the hand note contents, and the time of attendance of the execution of the said hand note is also found to be contradictory in the evidence of the case. Therefore, prayer has been made for passing an order to collect the expert opinion regarding the age of the ink used in the execution of written version contents of the hand note and of the ink used in the signature of the defendant in it. The learned engaged counsel for the plaintiff, on the other hand, vehemently objected to the prayer of the submitted that a petition is filed by the defendant just to cause the delay and drag the suit for another few years. There is no mechanism to determine the age of the ink, and defendant has already availed the opportunity to collect the expert report with regard to his signature earlier, and the reports of the expert is already available in the case record. The prayer is not maintainable and the same is liable to be rejected. Both parties have been submitted judgment passed by the various high courts in support of the claim. I have gone through the judgment and submitted by both the sides. After going through all the including the judgment passed by the various high courts, where different opinions were given as to the availability and non-availability of the mechanism of the determining the age of the ink and the facts of the circumstances and the instant suit at hand. This court is of the opinion that defendant shall get an opportunity to place his defense. Plaintiff says older objected that there is no mechanism available to determine the age of the ink. It will be seen once the report of the expert is obtained, but rejecting the plea of the defendant solely on the ground that there is no such mechanism, it will prejudice him. So once the report is sent for the expert opinion, it will be clear as to whether any such mechanism is available or not, and then the suit will proceed accordingly. Therefore, for the ends of justice and fair trial, my lord, for the ends of justice and fair trial, I deem it fit to allow the prayer of the defendant. The petition shall hereby allowed defendant directed to take steps immediately fixed on 26/2025. Accordingly, we have been allowed to take step for the expert opinion. Now, my lord, can you have a look?
So what is the last order?
Yes, well, last here is a final page 31 impugn order, annexure 6. That is on 17/7/25. On same date, my lord, 17/7/25, we made an application. The reason, what is the reason why we have failed to take steps on that date? We have reason assigned in annexure 5, page 29, my lord. On this application, very same day, this order has been passed, the impugn order, on 17/7/2025. The learned trial court has
rejected.
Yes, my lord. So, my lord, the final argument of the case is fixed on 6th of this. So, the honorable court, at the time of issuance of notice, we have been directed to take this speed post as well as usual post. But as registry record, I found that the service for the respondent is not complete. If it is 6 is fixed on. So, my lord, so interim protection may be given. Interim, the lordship TCR may be called for on arrival of the appearance of the respondent's priority. Finally, hold the matter, my lord. This is my respectful submission.
Mr. Kipedeka, return it for the petition. The office note dated 29/01/2020. This center, neither the AD card nor the answer notices return which were issued. We further submitted that considering the urgency of the matter, this court had passed the order on 19/12/2020. Take immediate steps for the respondents, but within 7 days, and accordingly the steps taken. But till date, the service report is awaited for the respondents. Mr. Deka further submitted that after rejection of their prayer for sending, after rejection of the prayer for sending the question document for determination of age of the ink.
Yes.
Stop. The matter is proceeding, and accordingly, it is at the last stage, and the case is fixed for argument on 6/2/26. Mr. Daka accordingly submitted that if the stay is not granted at this stage, the purpose of filing the present petition will be complete. considering the submission made by Mr. Deck and also the other aspects of the case, that the further proceeding in title, it was a title suit or?
Money suit, my lord,
Sorry, money suit.
of number 26 of
Suit
2020.
Number 26, 2020, pending before?
My lord, Learned Civil Judge Junior Division number 2, Hailakandi.
Division number 2, Hailakandi, state, next date. Service be awaited in next date.
This year may be called.
This year. This
Yes, deeply obliged.
Oh, sorry.
Yes.
Yes.
Forty-one, my lord, I has been filed for early hearing. Here, my lord, the petitioner respondent she is a decree holder and his suit was allowed. It is affirmed in the appellate court also. Then they filed the second appeal. It is pending from 2021 and they are enjoying the interim order. Their proceeding has been stayed. So any date in the month of March last week, my lord, this matter may be heard finally. Record has been.
What do you want to submit?
Lordship, earlier engaged counsel Mr. S.B. Rahman elevated to judgeship, your lordship. In this matter, my learned senior as judge will appear, lordship. We will file Wakalatnama, lordship.
It may be fixed for hearing and in the meantime they can file Wakalatnama.
But
Each
but it may be face some problem. Now your engaged counsel is, who is your engaged counsel now?
Lordship, now engaged counsel is my learned senior as judge, your lordship. We will file Wakalatnama, lordship. Not
Earlier your counsel was?
S.B. Rahman, your lordship. He has been elevated to judgeship, your lordship.
S.B. Rahman মানে কোন?
Syed Burhanur Rahman.
district justice.
Oh, it's a district
District
judge.
judge.
Oh, grade 1.
Lordship, grade 1.
So now your case is, the brief is now holding by whom?
As Das, your lordship.
S. Das. S. Das was here, I think. There. Has not filed his Wakalatnama now. Till then.
Not yet file, your lordship. We will file.
Mr. Hogg, it may create some problem if you fix the date today. Obviously, I can understand they are enjoying the interim, but still.
Widow, my lord, the
Mm.
petition.
Yeah.
Petitioner is a widow, my lord, and he is suffering from some illness. I have annexed the documents also, medical documents also. At least he should. Any day, my lord, in the month of March or April, a date may be fixed on that.
No, they are not. They have not filed their Wakalatnama also.
That is correct.
Heard Mr. N. Hogg, you done it counsel for the applicant. Otherwise, you are for the respondent.
I'm for the rest.
Applicant,
Degree holder.
respondent. And also your good name?
A. Rahman, your lordship.
A. Rahman, the learned counsel, appealing for the petitioner of the appellant. And the present I has been filed seeking the early hearing of the connected RSA
130,
130 of it. However, Mr. A. Rahman, the learned counsel for the appealing for the appellant of the appellant has submitted that the earlier the case was with Mr. S. P. Rahman, who is selected as a grade 1 of the district grade 1 officer in the some judiciary, and at present the brief is taken by Mr. S. Das, but they need some more time to file their Wakalatnama by Mr. Das. In view of this, I find that the present I be listed in the second week of March or third week of February.
Well, for this, my lord, it may fix next week, my lord, because they are filing the Wakalatnama only.
I don't know, they will be ready. It's
Next
a simple petition. It's a
Yes,
not
yes,
so.
my lord.
Next week.
Okay, my lord.
You want fixed date. Fixed date is not possible. We don't have any fixed date.
Next week.
Next week, any date.
Any.
And next week, after 1 week, as any date. Are connected. I RSA list accordingly. Heard Mr. Roman Blikova and N for the respondent list. the matter after 1 week. This the matter after.
Public.
May I please, Your Lord? Lordship, I am the petitioner, applicant of this instant IA and respondent number 1 of the MSC appeal. So by this IA, Lordship, I have paid to release the amount,
For releasing of the
50% of the award that is deposited by the appellant.
I
Yes,
don't have any objection. However, they may be allowed to furnish a indemnity bond before withdrawing the amount.
and this IA is your 2698.
Yes, 2698.
2698. You are Mr.
I'm S. Das.
Yes.
Lordship, my name is there in the Wakalatnama, but name is not reflected in the cause list.
You heard Mr. Esther, still an counsel appearing for the applicant public payment, and also heard
H. Buragun.
your name is also
My name is there in the post list, Your Lordship. H. Buragun.
H. Buragona, the learned counsel appearing for the appellant of the court. This is an application. This interlocutory have been preferred or filed, praying for withdrawal of an amount of rupees 2,10,759, which has been deposited by the appellant before the registry in pursuant to order dated 29/01/2021 in IA record of civil number 100 of submitted by Mr. Das that the claimant appellant is in need of money and accordingly paid for withdrawal of the same. Mr. Buragoha, the learned counsel appearing for the appellant, submitted has no objection in releasing disbursing the deposited amount subject to furnishing the indemnity. Considering this submission made by Spencer, the ST is hereby directed to release the amount which has been deposited for the registry in pursuant to order dated 29/01/2021, passed in IA civil number 100 of in connection with MSC appeal number 7 of 2021 to the claimant respondent after due and proper verification and on furnishing indemnity bond to them. With the above observation, the present
Lordship, copy of appeal memo not yet submitted, it may be given.
We have not received. MSC to take you. Heard Mr. S. Buragoha, the learned counsel for the applicant. Mr. S. the learned counsel for the respondent. You are respondent number 1.
Yes.
How many respondents are
There's one respondent.
Only one.
Two respondents.
Two respondents.
You are claimant respondent.
I'm the claimant. Respondent number
You
1.
are the claimant respondent.
Yes, yes.
And who is the other?
Your Lordship is the driver owner.
Not yet
Driver.
appeared.
We have taken steps, Your Lordship.
Taken
but they have not.
Still awaited. Stop. It will respect respond number 1 of the service on the no, here one order is there in the office note. I mean, office note is there on of 28/01/2026, wherein it is stated that you are directed to take fresh steps on the respond number 2 that has not been taken. Just take the fresh steps.
I'll take fresh steps.
From the office note dated 21/8/01/2026, it is seen that fresh steps is not yet taken for the respond number 2. In view of this, the appellant is hereby directed to take fresh steps on the respond number 2. In the same time, the appellant is also hereby directed to furnish a copy of memo of appeal to the respondent.
My name may be reflected in the cause list in appeal.
Further, the registry is hereby directed to reflect the name of Mr. S. Buraganwai for the appellant as well as Mr. Das for the S. Das, na?
Yes.
S. Das for the respondent. In the next. Let's go with which next 4 weeks.
Please, your lordship. Lord, this IA is for condoning delay of 114 days in filing the appeal, my lord.
My lord, I have
You
no.
are for the company. You
My
don't
lord,
have any.
All are represented. I am for.
All the
Objection
respondents.
to your lordship may allow that.
Only you are representing all the respondents.
No, I am for respondent number
1 to 4.
1 to 4 lordship, 5
Claimants.
claimant 1 to 5, but respondent number 5 has already expired.
So you are now appealing for 1 to 4.
1 to 4. And she is appearing for 6 and 7.
6 and 7. So all are represented.
All are represented.
So you also don't have any objection. But Mr. Hikari Tilani counsel for the applicant appellate. So far, Mr. Khan
Minute.
counsel appellate respondent number 1 to 4 and MS P. Talukdar appearing on behalf of Mr. K. R. Pakiri for the respondent number 6 and 7. This is an application in the Section 5 of the Limitation Act, related Section 173 of the MP Act for condoning the delay of 114 days in preferring a connected appeal against the judgment and awarded 30/11/2020 passed by learned member MSCT Bongaigaon in MSC case number 144. And where did you explain, have you explained your delay in any para?
My lord, 4 to 8, my lord.
4 to 8.
4 to 8.
So basically, this delay is for
Operating is certified copy, my lord, from Bongaigaon, my lord. Then the case record was transmitted to regional office at Guwahati from Bongaigaon divisional office, my lord. Then my lord, opinion was obtained from the dealing advocate, and the check had to be generated from Chennai hub office, my lord. That took some few days for that is called the delay, my lord.
Mr. Parita Dillard, counsel for the applicant appellate submitted that there was delay of 114 days in preparing the appeal, only for collection of the certified copy as well as to in observing some official formality which has been explained from para 4 to para 8 of the next. Mr. Khan and MS so-and-so also raised no objection and submitted that they do not have any objection if the delay of 114 days is condoned in preferring it. Next, but considering this submission made by learned counsel both sides, grounds mentioned in the petition, which are considered to be reasonably justified ground. The delay of 114 days in preparing the connected appeal is hereby condoned. The registry is accordingly directed to register and numbered and registered the connected and to list.
My lord, appeal may be listed showing our name, lordship.
What?
That may be reflected, otherwise lordship will not come.
Sometimes. Registry is further directed to register and number the appeal showing the name of the counsel which has already been appeared for the appellant as well as
Obliged.
Much only.
Milord, though we have filed one IA, Milord, and during stay, Milord, some construction work is going on in the place. Milord, this honorable court has state, Milord, but we have filed to again injunction, Milord, since LCR is received, Milord. So if your lordship fix them this appeal for final hearing in the first week of March, and then in the IA, Milord, though we have filed for injunction, lordship, so Lordship, kindly have a look at the one order, page 12.
Of IA?
Yes, my lord. This is the interim, the IA allowed by this honorable. Page 12, my lord, on 15th of September 23, while my lord, this honorable court has admitted my appeal on 3 substances current law. This is the in IA, my lord, page 13.
Yes, I have.
Yes, but lord, since it is there is
Stay was there.
stage under operation, my lord. But though we have filed this IA, my lord, there's certain construction work is going in that the disputed suit land, my lord. So everything will be decided at the time of hearing, my lord. My only submission at this stage, my lord, in the IA, my lord, lordship is directed. Already this honorable court has passed order on 15 September 23. Then same order is still on force. Same may be directed to compliance, and rest may be directed to fix the matter for hearing the first week of March. That much. I'm not pressing, my lord. If I agree. Yes.
But I have no objection.
Yes, my lord.
If the matter is fixed on February or March, my lord, for final hearing.
February, in the last week of February, first week of March. Yes, lordship.
No, then it is one. It is an 39 only impact.
My lord, that
So
already this honorable on 15 September 20 state, my lord.
was already appointed, but you are saying that in spite of stay, there was some constructions.
Yes, my lord.
So now you are going to press this one, or you are not going to press?
Not so far as my eye is concerned, my lord, injunction is concerned. Instead of lordship allowing the injunction, my lord, lordship is simply direct make a that already this honorable court state the findings of the learned appellate court below. It is strictly compliant. That much.
My lord may do one thing, my lord. My lord may keep this IA pending, my lord, and if the main matter, let me fix for final hearing.
That's what I'm saying.
Yes.
Yes,
So it
lordship.
is a injunction.
Yes, lordship.
and because against stay
Yes.
cannot be.
Lordship. Yes, lordship. Yes.
MA it would be connected RSN. But Mr. PK, they have done it for the applicant. So it's still on it. Council appealing for the response. Name of one respondent pro forma is already struck off. We have received the TCR now. TCR has already been received. Let the matter be accordingly listed for final hearing. On you are saying on the March?
My lord, on 5th of March, my lord. Otherwise, the registry not fixed. Your hearing date is to be fixed.
Fix will be immediately after holiday.
The 10th of March.
Legally, well, I could do.
He's saying that many motors have been fixed. So at best we can fix it if you want
Second
to
week
fix
of
it.
March.
Second week of March in a sense on 17th of March.
Yes,
That
my
can
lord.
be.
Yes, my lord.
So we are fixing it on 17th.
Yes,
of
my
March.
lord. Yes.
I simply leave it.
That I may be kept pending of this.
List accordingly along with RSA. And so on 7th.
Deeply obliged.
I know.
Hearing the hearing of appeal.
Yes, yes, ready.
Ready.
Yes, I'm ready.
Appeal.
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 Yes. There are one FAO has been filed and they have filed an application for violation under order 3902A, but appeal can be, FAO can be heard. If we find that there is a violation, automatically your lordship will know that there is a violation of. They file an affidavit and we file a reply after that on 28. That can be called at any moment of time. One affidavit has been filed by my learned friend. It has come on record. He said it's come on record. Yes, no problem.
Already on.
Yes. আমাৰ খন আহিছে নে? আহিছে নে? Our reply has also come, my learned friend has said. Our reply has come. That is not so,
It was in IA with 83829.
IA,
No, that was fine. Yes.
my lord,
Number is
কোনটো আহে? 95,
95.
কোনটো?
I think.
Yes, 95, my lord, 90
95.
is a violation.
9526.
It's a,
File your objection also.
IA we did not, I mean, additional affidavit we filed.
They have filed additional affidavit.
They filed an additional affidavit. I mean, contempt file for filing.
Violation of it.
Affidavit file for violation. We filed affidavit in violation also. Violation on order 39, rule 2A, we filed an affidavit in that case. Now there is an additional affidavit but in contempt. They file additional.
Again,
They file one particular and we,
affidavit and additional affidavit filed by
and
them always.
yes, already is there. And my reply is also there. I can reply on us. Reply. My learned friend said that their additional affidavit has come, but my reply I have filed it. My reply also I have filed it in the morning today. Copy, copy. পিছত দেখা না হাইকোর্ট সার্ভিস হয়েছে দেখা না সার্ভিস কোর্ট হয়েছে দেখাবে তো
We have not
সার্ভিস
received
হয়েছে না
record. Whether it's
সার্ভিস রেকর্ড করেছে না
no, whether you have served the copy to the
That's why I'm asking. কার করিত সার্ভিস ক্লাস টু করলে কেন গম পাবো দেহ সার্ভিস করবো লাগিব না
additional affidavit.
No, you can hear this. Nothing to do with that. Yes, right. May not be completed all. Well, I will start. I will start it. I can start. But I will start it. I will start the case. Let's start. So your lordship is hearing FAO 75 of 2025. My lord will kindly, this is against an impugn order that has been passed by the learned Civil Judge Senior Division number 1. That is at page 421. Impugn order. Just your lordship can note down. I will read the impugn order later on. First, your lordship should know what is the facts of this case and what resulted to pass this final order, impugn order. My lord will kindly see at page 35 first. Yes, page 35. This is, my lord, application under 145 CRPC was filed. Now, if your lordship kindly see, kindly see before that, see we have given the tree, how it was inherited, how it has come. Kindly see this one. Who does it? Kindly see that tree, my lord, which was given. It is already in the file, I think. Only I will not read, I will give a tree of it. How the your lordship can note down. Other side of the ball. Enuka no hoy. Those proceedings.
My lord, originally the property belonged to one Kaliram Medhi. Kaliram Medhi. Now, the Kaliram Medhi has got three sons. One is Rambhadra Medhi. My lord, deceased, he died. Rambhadra Medhi. Rambhadra Medhi. My lord, he is no more. Another son is Surendranath Medhi. He is also no more. And another third son is Subhadra Medhi. Subhadra Medhi is no more. Now, your lordship, please note down, Subhadra Medhi did not have any legal heirs. Now, Rambhadra Medhi, now his son is Veerbhadra Medhi. Veerbhadra Medhi. Veerbhadra Medhi. Now, Veerbhadra Medhi has got three issues, three sons. One wife, Dyoti Khana Medhi, and two sons, Aniruddha Medhi and Duskanta Medhi. So, wife and two sons. Surendranath Medhi, who is another son, your lordship has noted down, who is no more. He has got a wife, is Bandhana Medhi, and Bandhana Medhi has got one daughter, is Barnali Medhi. Now, Subhadra Medhi died, Subhadra Medhi died, I said, my lord. Now, he has no issue. So, he left a property, which is, your lordship will kindly note down, it is 3 kathas, 10 lechas. Other side there. Yeah, other side of photo. I told him we exchange always. He also knows we exchange. When list of dates, I said don't give it unless it is not given to him also. My lord, your lordship is see the tree. Got it? My lord, tree. That's now it will become easier. I have given a tree. Kaliram Medhi, Rambhadra, Surendran and Subhadra. Lordship got it. Now this Rambhadra has son Veerbhadra Medhi. Now they have got wife Dyutikhana Medhi and Aniruddha Medhi is the son. Duspanta Medhi is the son. Lordship got it. And now from next column say Surendranath Medhi is deceased. Wife is Bandhana Medhi. Daughter is Barnali Medhi. On the right hand side column, Subhadra Medhi deceased. There is no legal heir. Right, my lord? Please note down Subhadra Medhi while he left, while he died. So he has left, he has 3 kata, initial 3 kathas, 10 lechas of land. Now in 2 dags, please note down that's important, the entire dispute. Now these 2 dags, dag number 1324, in dag number 1324 is 3 kathas and dag number 1323 is 10 lechas. Right, my lord? This is the history. Now, this property, by a will, it was gifted to us. That is, it was gifted to Veerbhadra Medhi. That is on the right, left-hand side of the column. Left-hand side of the column, it was given by a will to Veerbhadra Medhi. Right, and this is about 3 kathas, 10 lechas of land, which is which is now being by way before a district court for a probate, which is pending before the court. Right, my lord? Will probate pending before a court. I'll come later, it is here also. Now, how it started, my lord will kindly see at page 35. The list of dates also is written by 35. Kindly see in respect of the same property, my lord, which was gifted by a will. It was to donate, given to my family, I'll tell family, by Subhadra Medhi. Now there is a dispute in between family. That second part, if your lordship kindly Surendranath Medhi's, that is my lord the wife, Bandhana Medhi. They said that we are in possession of that disputed property. It is among family. We said that no, it has been gifted. By will it was to us. How can it be you in the property? So what we have taken a step. The son-in-law of Virubhadra Medi, my lord, he files an application before the learned magistrate under 145. And this is the order that has been passed. Kindly see the order, my lord. This is of, kindly note it down. Date is 22/3/2016. Lordship got it? The order of the magistrate, 22/3/2016. Lordship will find a list of dates also, no problem, list of dates. Now, kindly see one, follows Kamal Borua, son of late Birendra Khan Borua, so and so, versus Bandana Medi. Now, case record on transfer, so and so. I am satisfied that your lordship will leave. However, for the now, hence I draw up a proceeding under section 145 CRPC, directing both parties to appear before this court for filing the written statement and other connected documents, if any, in support of the respective claim over disputed land on the next fix. However, for range of justice, both the parties are directed to maintain status quo over the disputed land. OC Bhorolmukh, so and so. Now, schedule of the land. All that part and parcel, this is the schedule of the land, which is in dispute. Because now she said, I am in possession. I said, no, it has been given to me by a will. Now it has been probated. Now, kindly see at page 36. In the meantime, we file a probate. My lord, probate was filed before an additional district judge at page 36. And we also filed in the probate an injunction application was filed. This is filed in 2000. Title, your lordship got PTS number 5 of 16. And this injunction was filed because now Bandana Medi was there in possession. So I have to file some type of injunction restraining her to not to create a third party right or to maintain a status quo order. Now this order was passed 30/11/2018. Now if your lordship looks into the second paragraph, the brief of the petitioner case, the petitioner filed a probate miscase praying for grant of a probate in respect of the will executed by late Subhadra Medi in respect of the estate by said testatrix. It is further case of the petitioner that a testatrix by executing the will in question in respect of so and so, it is further case of testator by executing the will in question appointed him as the executor of the will and bequeathed the Schedule A property in favor of petitioner. It is further case of the petition that he has come to know OP number 8 has been trying to change the nature and feature of Schedule A mentioned property and started construction of an RCC building with a view to grab the property, which will cause irreparable loss. So the petitioner filed petition under considering praying for temporary injunction as prayed for. Now, my lord, notice, so this is your lordship can read. This is the case. 145 was narrated. Now, how the court dealt, kindly see at page 38. See 38. Secondly, the petitioner filed a petitioner claiming injunction. Lordship got it. Pending disposal of the petition for grant of probate, only when the probate certificate is issued in favor of the petitioner that he would acquire an interest over the property involved in the probate proceeding. In such a case, at present, balance of convenience or inconvenience would not be tilt in favor of the petitioner. Moreover, when the petitioner has no right, title, in interest and possession over the scheduled land, there cannot be any loss, less to speak of irreparable loss if injunction is refused. On the other hand, the answering opposite party being undisputedly in possession of the land in question, if restrained by grant of injunction, his right to property, a constitutional right, would be restricted, and as such, restriction curtailment would entail irreparable loss, as curtailment restriction of any right cannot be compensated in terms of money value. So balance of convenience inconvenience also found lying against the petitioner, as all the three golden principles governing grant or refusal to grant injunction lies against prayed for grant, the miscase stand dismissed. So my application was not allowed. Now this was also not put to challenge before any court. Correct, my lord? This is the position. Now, what has happened, my lord? Your lordship has seen the order of the injunction 2018. Then PTS file of 5/2016 that is registered. Now, in between, at page 41, lordship got it, my lord? 41. Kindly see the sale deed, one sale deed was executed in respect of the same property in dispute. The property in dispute. This property in dispute, sale deed, they said it is Subhadra Medi. Now, if your lordship kindly see, this deed of sale is made on this, it is all gap. Now, by Subhadra Medi, lordship got it, my lord? Now, please turn. Here it is 42, it is mentioned this, but in that there is no date. 43, kindly see. Pradeep Kumar Das, son of so and so, called and referred to as purchaser. What you call it? Purchaser, sell unless and otherwise so and so. He becomes a purchaser. So their case is that it has been sold. This property in 2008. Also got it, my lord? 2008. Now, the property which is in question 44 is a serial, which I just a 3 cutters that is narrated here, whereas seller first part, lordship got it? I am not trouble. See 46. 46. On the clause 3, that the vendor has conveyed and delivered the actual physical possession of the said land to the purchaser as per schedule below with the relevant records and papers. So at the time when the sale deed was executed, here it is narrated that it was delivered the actual physical possession. Now, now, my lord, kindly note the date, 2008. Now, thereafter, he kept quiet. He has not done any mutation. He was sleeping over that by way of a sale deed. Now, if your lordship turn to page 50, now, kindly see 50 mile. Now, this is the mutation. So by Pradeep Das, Pradeep Kumar Das, kindly see on the top. Now, see the order of 2010-2022. Got it? Now, please turn to page 51. After first 4 lines. I will not read the entire because it will take about 4 days to read. I will just put in what manner in short I can do it. 51, kindly see top, first, second, third, fourth, fifth line. In his objection petition, now, my lord, once we knew that, my lord, a sale deed, our whole case that the Mr. Pradeep Das was never in possession. We went there when we came that after so many years, and your lordship will kind note down, 2016, when I file a probate, it is a family dispute between us by my cousin who said happened to be in possession, where I file an injunction against her. Because it is my family dispute. Your lordship has noted down, injunction was refused. So at that relevant time which was going on, how my case, how it can be sold. Then we came to know all this was without any permission. No permission was taken. Now, he waited, Pradeep Das waited, and after a gap of 14 years, he, my lord, goes before a circle officer, applies for mutation. Once we came to know, we filed an objection. And in an objection, please see 51, first line, 1, 2, 3, 4, 5 line. In his objection, lordship got this petition. It is mentioned that the aforesaid Subhadra Medi, son of late Kaliram Medi, has executed a will in the name of the father of the objector, late Birubhadra Medi, in respect of the aforesaid property and probate miscase, bearing number so and so and are pending in the court of civil and assistant judge so and so. And in the court of civil and assistant judge, hence prayed for not to grant injunction in the said until the disposal of the said case. Also peruse the Lot Monal report, related record, so and so. But whatever he narrated, kindly see the last 4 lines, at page 51, 3 lines. Again, the sale deed, why deed number 15840 dated 31/12/2008 of the land in question was registered prior to filing of the probate miscase number 12/2016 and title suit number 130/2018 in respective honorable court. Hence, the objection petition filed by objector cannot be considered hereby rejected. Considering all the aspect and being satisfied, so and so, so and so, so and so, so granted mutation. So my objection was also rejected. And after 14 years, he files the mutation application before the authority, revenue authority. 2016.
2016.
Yes. 2016. And this sale deed was 2008. Sale deed. And mutation was in 2022 order. So there was an objection which was it that was not considered. Now kindly see at page 54. This was sold. This was sold. Pradeep Das, once he got mutation, my lord, less than 1 month, he sold this particular property. He sold this property to one Sarita Devi Jain. Kindly see at page 54, right? Textbook 54. And when it was sold, my lord, kindly see. 17th of November 2013. Sarita Devi Jain is the respondent in this particular case. Who is my learned friend is appearing. Pradeep Das also, we made a party and we have sought for subsequent. That's why I said if I go to the facts, then it will be easier to connect with my suit, which we have filed. So now Sarita Devi Jain, my lord, there is a sale deed less than a month. Hurriedly he went and he sold it. He sold his property to Sarita Devi Jain. Now, this was done at page 56, 17th day of November 2013.
22.
Sorry, 2013. 2022, there is typo mistake, but original I have given at page 50, sorry, huh? 17 day of that 56A. This is the copy original. See, kindly see 17th day of November 2022. At page 56A, my lord.
It should be 2023.
22. Well, kindly see this deed of sale 56A. 56A. This deed of sale is made and executed on 17th day. At page 56A. What you got it, my lord? 61 of what? And the
Yes, yes.
What you got it? Right, my lord?
Yes.
Then they applied for mutation, Sarita Devi. Once the property was sold by Pradeep Das, we waited for 14 years, thereafter mutation order passed, thereafter less than 1 month, it was sold to Sarita Devi, the same property. Now 71, now this is a mutation case, number so and so, not to find it.
71.
71, where they have applied for mutation. And your lordship kindly see, at least from my side, subject to corrected, I am corrected by my learned friend. I have seen on the left hand side, I have not seen any date here. At least if I can be corrected, my lord, but from my this, I have not seen any date here. Now, this is the same property, 2 lands. Lordship will kindly see first, second, third, fourth. The case is fixed for hearing. Applicant Sarita Devi Jain is present. Submitted Haziza, heard the applicant. Seen the petition submitted by appellant is Sarita Devi Jain, wife of so and so, mutation of land measuring so and so. covered by Dag number 1323 of KP Patan number so and so, so and so. Now, my lord will kindly see third paragraph. See the third paragraph. Also peruse the lot mandal report related available office record of land in question, other documents submitted by applicant. Concerned lot mandal in this report has mentioned one, namely Dushmanta Medi, son of late Birubhadra Bhadra Medi on 7/8/2022, while receipt number 1202 has filed an objection petition in respect of granting mutation of the aforesaid land. Again, we file objection. Now, kindly see the last. Considering all this aspect and on being satisfied with the manner, application, mutation, name of applicant in respect of land measuring so and so, so and so, it is hereby directed the records of the name of the applicant, Sarita Devi Jain, wife of Sri Sushil Kumar Jain, in the records of right of the aforesaid land in place of existing recorded partner Sri Pradeep Kumar Das, son of late Madan Chandra Das, lot mandal to correct the land, so and so, so and so. So my petition was also not accepted. Now, my lord, at 72, two Dags, one is Dag number 1323 and this is Dag number 1324. Now, this is the same because I told my lord there are two Dags. One is 3 kathas, one is 10 lectures. So, two separate mutation order because two Dags. Now, their same order, they rejected the application contents. Now, my lord, I could not do anything because I just complained also, this is what property is pending. And I raise an objection, serious objection. And less than a month, you sold this property, you want to get out, rid of this. Pradeep Kumar Das. He knows that he cannot be in possession of the property. So he was keeping quiet. Even when he was holding the sale deed in 2008, and he was keeping quiet till 2022. 2022. Apparently, it appears from this. No one. Why, if I have a sale deed, immediately I'll go for mutation. I will not wait for last 14 years to get it muted. Then immediately when the mutation order was passed, immediately it was sold, transferred to one Sarita Devi. Now, my lord, once we came to know, we didn't have any alternative. So it is only by a suit we can approach before this court for cancellation of these two sale deeds. So we approached the Civil Justice CDA Division number 1 for filing a suit. And that your lordship will find at page 73. My suit which was filed. That is title suit number 505 of 2023. Lordship got it, man. Now please treat 1 is the wife of late Birubhadra Medi, plaintiff 1. 2 is another son. 3rd is this is another son. 2 sons and 1 mother. Now they file against Pradeep Kumar Das, 2008. I have to, my lord. If his deed is gone, if this is his deed has to go, then automatically consequential that say lead will go. Now, second is Sarita Devi Jain. And these are the performer defendants. All are related performer defendants, my lord. Got it, my lord? It is not been contested. It is an expertise, as my learned friend has said. Now, my lord, kindly see now. The prayer in the suit is fine at page 93. We fight, but we exchange everything. We fight. I said the water is nice because the mulot ase too. Like in a sports field, it's a sports field also. Sometimes he may get agitated, I may get agitated, that's different. In sports field also is same. The opponent, he also played. I also played. So same. We exchange water, but there is always a fight. So in a sportsman, always there is a temperament. Maybe anger at one point of time, but that spirit always will be carried. One will lose and one will win. That's a part of it, man. Now see, 93. One is a declaration to the effect the recording name of late Mandana Medi, wife of so and so, by order dated 18/4 passed in mutation case by circuit so and so. So we sought for declaration because that mutation. And now B2, a declaratory decree declaring that the alias deed of sale bearing number so and so purported registered on 31/12/2008 with the office has been fraudulently created by forging the signature of late Subhadra Medi, and the same is invalid. Now 3, a decree of declaration to the effect that the order dated 2010/2022 passed by circle officer so and so on the basis of a fraudulent deed of sale dated so and so has been obtained by defendant number 1 by playing fraud on the revenue authority, hence is a nullity and honest in the eye of law and not binding in respect of Schedule A property. Now 94, a decree of declaration to the effect order of mutation dated 2010 passed in mutation case number so and so has been obtained by defendant practicing fraud, and hence the same is null and void amnesia. 5, a decree of declaration to effect registered deed of sale bearing dated 17/11/2022 executed by the defendant number 1 in favor of defendant number 2 on strength of deed of sale bearing number so is invalid, illegal and null and void in the eye of law. And 6, my lord, a declaration to the effect orders purported dated 16/6 passed by circle officer Guwahati Revenue in mutation case number so and so, name deleting the name of defendant having been obtained by playing fraud so and so so and so. 95, a decree of the eviction of the defendant so and so and assigned from the Schedule A property to the plaintiff. Now these are the decree for permanent injunction, cancellation, issuance of precept, all has been done, right, my lord? Now, on the basis of the suit which we filed, now they appeared before the trial court, civil court. And 99 is a written statement of Pradeep Das. Now, 101 written statement, my lord, at page 101.
Yes.
I will tell your lordship in this case, if it goes against me also, I'll point out. I'll point out, which is, that's why I am reading paragraph 101. What page 101, what is a written statement of Pradeep Kumar Das? Initially, a sale deed was executed. And what is the stand in written statement? Kindly see paragraph 12. Para 12, from the bottom 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line. So 10th line from the bottom. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. The defendant number 1, what you got it?
Yes.
Has been in possession in the suit land after purchasing the land from Subhadra Medi, and Birabhadra Medi was well aware about possession of defendant number 1 and also about the execution register sale deed by Subhadra Medi dated 13/8/2008. So he said, I have purchased it 2008. By virtue of that, your lordship has looked into it that possession, I got the possession of property. That is what his statement, that I purchased 2008 and possession was with me. This is what is the basic stand. Now, if your lordship now looks into the 111, that is defendant number 2, my lord, Sarita Devi Jain, filed his WS and counterclaim. There's a counterclaim. Lordship got it, my lord? Page 111. Para 7 kindly be seen. Page 112. Page 111. 111 is the counterclaim. 111.
111.
111 is the counterclaim, and please see para 7. 1.
Yes. In 117.
That the suit of the plaintiff is bad for non-joinder, misjoinder of necessary party as a plaintiff has set for relief into the entire LA suit dark and patta land structure standing thereon. Second paragraph is 11 at 113. 113. 113 second paragraph. At the same time, 113 second paragraph.
Yeah.
Sub-para. At the same time, the implement of ensign defendant number 2 counterclaimant in the suit is absolutely bad for misjoinder of unless party, and the ensign defendant number 2 counterclaimant has privity of the contract with the plaintiff in any manner, and the ensign defendant number 2 counterclaimant have acquired the alleged suit land from defendant number 1 whose sale deed in actual physical possession over the alleged suit land remain unchallenged on and from 31/12/2008 till execution of sale deed dated 17/11/2022 of the ensign defendant number 2 counterclaimant. If at all, assuming for the sake of argument but not admitting that the malified plaintiff were having any kind of right title over the suit land, or then also the same has been extinguished by application of doctrine of adverse possession of defendant 1, who was in open, clear, and hostile position over the alleged suit land, which was vacant land as on 31/12/2008. And subsequently, Assam type construction were raised over the same by defendant number 1 since after 31/12/2008, which was later on transferred to answering defendant number 2, counterclaimant by registered sale deed number 17/11/2022. And since 17/11/22, the answering defendant number 2 counterclaim is in exclusive, actual, physical possession of the same without any claim or obstruction from the malified plaintiff in any matter. Hence, the suit of plaintiff is totally bad for non-joinder and mid-joinder on necessary party. As such, the suit of the plaintiff is bad in law and the plaintiff and facts and liable to be dismissed. So basically, this is stand Vijay that by virtue mere purchase of the property, we are exclusively holding the possession. Now, kindly see. See at page 133 is a prayer by defendant number 2, 133 mile.
Yes.
See paragraph 2, Roman 2, declaring that the answering defendant number 2 counterclaimant is the bona fide purchaser, purchase on valuable container below, plot by way of registered sale deed from earlier owner and Patadar, defendant number 1 of the suit, and hence acquired bona fide and lawful right, title, interest, and possession over the below civil plot of land over which none of the plaintiffs are having any kind of vested and legal right in any manner. Right, my lord? Now, this I think 3 declaration, Roman 3 declaration the alleged will dated 17/1/2015 is a mere forced, fabricated, illegal manufactured document of the predecessor of the plaintiff, and the alleged executant of the same was not having any such transferable right or the alleged suit land in view of existing unchallenged lawful sale deed and also having possession over the same defendant 1 at a time, and hence said will nullity in the eye of law. Absolutely forced, fictitious, illegally manufactured, same is neither binding upon the defendant of the suit nor binding over the so and so, so and so. So now in the suit also challenging my will, which is in dispute between the family, which is pending. Now, 4, my lord, declaration that the answering defendant number 2 counterclaimant being neither a party nor her land has been involved in so and so. This is not connected. Different plot of land. 5, confirmation of her position. Kindly see confirmation of her position over a schedule B so and so and land underneath by right of bona fide purchase on valuable consider over which plaintiff are not having any semblance of any kind of right, title, interest and position in any matter. So now confirmation of a position, once you are in position, only you can claim right title. There is a question of confirming your position. But whatever may be, this is a prayer which has been made before a suit. Now, for the 6th, my lord, at page 135, permanent injunction restraining plaintiffs, their servant so and so, causing any kind of obstruction, threat and so and so. Got it, my lord? So this is
We'll do one thing. Up to 135 or something I have already noted down. So no need to repeat for all these things.
Yeah.
As you have submitted already,
Yeah.
I have already noted down. So we can hear you it is, your part is also not completed.
No, no, no.
So I can understand. So,
Only I have one
tomorrow-
difficulty. I'm
Huh.
telling your lordship. On third, fourth, fifth, there is difficult. On third, fourth. Third, fourth, fifth, there is difficult. Sixth,
what will happen on the
no, subject to my learned friends.
no, third, tomorrow is third, no?
Tomorrow I can do it.
No,
yes.
tomorrow I have a division bench and already
Oh.
hearing matters are there. So Wednesday is I think fourth. So can it be on fifth?
Fifth,
If it remains on a part third, then it may be hard.
Sixth.
Sixth again, it is a Friday.
Sixth.
Again, another mention.
Sixth, seventh is also court is there.
No, seventh. We are not.
No, seventh, I think court is there here. This time,
Yes.
court is
but
there.
not hearing matters. We are not taking the hearing
No,
matters.
I want to
There
finish
are
it off,
many,
my lord.
pending
I
matters
want
are
to
there.
finish. I will finish that part on sixth. I will finish. You'll give me
No,
one.
fifth you can be fifth.
Fifth, I am
Because
not
it is
here.
a hearing day.
I am not here, my lord.
Fifth you are not here.
Not here, my lord.
Tomorrow is also a hearing day, but tomorrow may not be possible in a sense because I have a division bench, then only again single bench. There are lots of many hearing matters have already been fixed. So Wednesday, I don't know. Wednesday you are here? Wednesday,
Fourth, fifth, I am not here.
fourth and fifth.
Fifth. Sixth, I will be here.
Sixth not,
Sixth, 1 hour time, I will finish it off.
Hearing day. Friday. ইমান অলপমান কমাই লিষ্ট কৰে তেতিয়াহ'লে শুনিব পাৰিম।
2 o'clock if this matter or morning, my lord. Because then it remain afresh. Subject to my learned friends also availability.
Sixth of the day. At 2 কৰি দিম। We'll do one thing, if it can complete it on 6th, then we'll fix at 2.
Yes.
At 2.
Yes.
Then it may be, you may be finished your part, at least your part.
My part I'll finish.
Your part. Then
I assure my part I'll assure I'll finish it.
because now, till now, whatever I understood that
135, your lordship has.
up to 135. So that claim was there by this defendant number 2 or the Sahiba Division. So that is her counterclaim,
Yeah.
and your part, your stand is you have already submitted. So there is 6th or at 2 already. This matter as a part on 6 2025 at 2. We are listing at 2 p.m. So
There is an interim order that will.
This is status quo order.
Status quo order will continue. Yes.
Lordship last order. Lordship's last order. Lordship can continue. That is clear, Lordship. Lordship's last order. On the day when the first appeal was admitted, on that day, second day, Lordship's order. 28th January, Lordship. 28th,
It was in IA.
20.
It was in IA.
Yes.
It was
20. Lordship is
IA. IS. What was the IA number? IA number?
95.
95.
In the appeal, your lordship has passed that order.
Oh,
Kindly
अच्छा,
see.
okay.
In the appeal, your lordship.
Yes.
Yeah, that's fine.
Yes. They will. The interim order dated 20/01 passed in connection with IA Civil 95/86 in connection with the present appeal. Be continued till next.
2 o'clock.
At 2. At 2. Short at. Yes, I have listed on 20/01/2026. That will be continued.
I'm deeply obliged.
Till next date of listing, it will be continued as well.
I too.
No, I have passed the order on 20. Mr. Sharma, I have passed the order on 20. That order will continue.
Lordship.
One order was passed in connection with IA. So and so.
Subject to that IA, Lordship. That is-
Yes. Here is this. They have rightly pointed out, Mr. Das. It is already here. So that order will continue till next date of listing.
I'm deeply obliged.
Okay. Is there any confusion? Please tell us. Is there any confusion in that regard?
No. He said, Lordship, the status quo should be If the lordship there, lordship on that day,
On that
lordship,
day, I have passed the order, only strict compliance is there.
Yes.
So that's why I have mentioned the order, dated order also,
there
20
is no compliance, lordship, that's the whole problem.
No, I have written down the order, dated order, 20/01/2026.
What
That-
you
That 20-0.
Yes, 20.
Yeah, it's not. Okay. What is it?